We're very happy that you're here. And an entire team from the commission is here. There's also Petronila Mukaindo, there's Dr. Elizabeth Kamundia, and there's Faiza. I think it's really a good show of commitment that we are all here to support this cause. And then all the participants, those who are here in Kabarak and those who are attending virtually, allow me to say a big thank you for taking this time to be with us. And I'm sure that you're also going to make a very serious contribution to the discussion once it takes off. I'm meant to just do remarks, or just do remarks, one or two things, that I could say at the beginning. One is to say that I've been thinking a bit about the colonial epoch and its impact for many years now. And as we speak right now, I'm working on a book, helping a friend to make a book. That's what I do in my other life. I'm an editor. I'm a press worker. And that book is about the history of our constitution from the colonial days up to now. I was reading a bit about Littleton Constitution, Lennox Boyd Constitution. Remember those things that we did? Remember they're named after the colonial secretaries, the Westminster, after us. But really, the struggles appear to have been so much political representation and racial. How many Africans will sit in the Legislative Council? How many Africans will guide? That's where the discussion is. The discussion was not on other critical rights like the ones we're talking about. It is not that this wasn't an issue. In fact, when Lady Justice Grace Nganya gave me a chance to work with her on criminal justice reforms, I noted that the Criminal Procedure Code and the Penal Code are still outdated, all of them, referring, for example, to people as imbeciles, insane people with unsound mind. That's what it says. Those were not the struggle for independence. It was not part of that discussion. And it appears that at that point, we hadn't begun to discuss rights properly for everyone. It also appears that even for the few who could discuss rights, like the white settlers, their preoccupation was representation and control of government, not human rights. So what we are doing here today, I believe, is to continue the decolonization project that was not complete. So I think what we'll do is therefore very important and must be seen together with the language of decolonization that is taking shape in Africa. Because most of what you will see we are suffering in the criminal justice system has nothing to do with ourselves. It has a lot to do with the institutions and systems that we inherited. I'm glad and I'm really, really happy that Justice Ngenya is here to be our chief guest, because the judiciary in Kenya is one of the few organizations that actually reformed, if you ask me, from where I sit. Among the few institutions that have been able to force change and even question some of the problems we have undergone as a country, especially this area of persons with intellectual and psychosocial disabilities. For example, judiciary has questioned, detention of the president's pressure. They have questioned a bit of, for example, that. And it shows that the judiciary, therefore, is concerned about proceeding with the reforms where we stopped. When we join them, as we do now, to give further discussion, I think we are really, really helping our country. So I'm quite excited, in other words, that we are all coming to further a project that was forgotten when we negotiated our independence. I hope that whatever is deliberated here, therefore, is going to be useful, not just to us, but to the entire republic, and especially those who might not even be able to speak for themselves at this point because of a situation or another. As I conclude, allow me to also mention something that has bothered me a bit, looks a bit, sub judice, but it's something that I think I should flag out because it is important. So as we discuss this, I see a Gazette notice saying that a judicial officer is being taken through a tribunal process for an issue that for me might appear to be either sickness or a disability, I'm not very sure. And that goes to the root of what we are discussing today. I asked myself, if my staff is sick, I'm dean here, I think the easiest thing to do would be to look for medical care for them. If they were having a disability, then the other easiest thing would be to enable them, maybe provide provision for them to access whatever they can. If it was, if, for example, they were blind, I'm able to ensure they have braille. If, for example, they can't come to this floor, maybe try and find ways for having a ramp. You know, I think that's what you do with disability in the context. You don't punish someone for disability or sickness. Whatever it is, you decide it is. But I'm just speaking out of context. But it goes to the root to show that even though the judiciary has been the most reformed institution, it also suffers, even internally, and some of its members can suffer. And when you see a judge being dealt with like that, let me use that word, it tells you that the ordinary Wanjiku, Atieno, you know, or Manjala is going through a worse crisis, which is why this forum is very important for me as well, that we are in a position to discuss critical issues for our republic. And so feel free to air your views, because you can be you know, encouraged by the fact that you're speaking for someone else. And it could be as high as a judge, but it could also be as low as an ordinary person without means of survival today, without capacity to even realize that their rights are being violated today. So that's really the spirit in which I think we should attend to this conversation. Thank you very much all. And now allow me to invite the next guest, who luckily for me is also right here, Dr. Mugesa from the Kenya National Commission of Human Rights, our co-partners in this forum. Thank you.
Good morning, everyone. Thank you very much, Prof. and the Kabarak University Fraternity for this opportunity for us as KNCHR and for myself to interact in this particular session. Prof, I would like, just before I make my remarks, to pick from where you've left, that indeed matters of mental health, matters of disability are a concern to all of us. I remember in my other life, when we used to campaign for inclusion of persons with disabilities, we used to meet lots of obstacles on our way, and to the extent that some people usually gave us very negative reception. Disability does not knock the doors to everyone at the same time. It can knock your doors today. It can knock the doors of your relative tomorrow. It can be your child the next day. So as a country, we need to be very much prepared. I don't want to re-echo, Prof, what you mentioned about the judge who is facing the tribunal, but I know as a commission already, we have made a communication to the Chief Justice, giving our position as a commission on this matter, like an advisory for her consideration. So it is very important that as a country, we take cognizance of that. And Prof, allow me to say that that action also reminded me of one of my professors in the special education class in the UK when I was doing my doctorate. Actually, this lady was autistic. And therefore, we were taught, wherever she was in class, how to handle her. So it became learning sessions for us that, given an opportunity and the way we treat persons with disabilities, persons with mental health, they can play a very vital role in society. It's a question of availing that chance and understanding how to deal with this. So ladies and gentlemen, this morning I'm very happy on behalf of Kenya National Commission on Human Rights to make these opening remarks. At this point, I recognize the Vice Chancellor, Kabarak University, who is to join us later on, the DVC Academic and Research, University Provost, the Dean, Kabarak Law School, and the entire faculty of School of Law, Chair of the Committee on Criminal Justice Reforms, development partners present, honorable presenters, esteemed participants, students, ladies and gentlemen. Kenya National Commission on Human Rights, as you are aware, is a constitutional body for the promotion and protection of human rights established under Article 59. And of course, our operations are further guided by our constitutive act, Kenya National Commission on Human Rights Act of 2011. And of course, our mandate is to promote and protect human rights and freedoms in the Republic of Kenya. And we do this using a number of strategies. For instance, receiving and resolving complaints, lodging or being enjoined in public interest litigation. And I think this is another area, Prof, which is very rich, not only in terms of research, but also in terms of further exploration on the extent to which then we can, bring and highlight certain matters of interest in the judicial process in this country. We also undertake audit, research, and public inquiries. And I'm proud to say that if you visit our website, there are quite a number of these documents that we have published that can be very useful even for education disposition as well. We do lots of advocacy work, legal reform through the advisories like the one which I've just mentioned, and most recently also, we did one to the Minister of Education regarding human rights situation in our education sector in Kenya, and especially during this period of COVID-19. We also interact with various partners as a commission, CSOs as well, and this gives us the energy, therefore, to harness the potential across board so that we drive Kenya into a human rights respecting state. I'm also happy to say that as a commission, since our establishment, we have maintained our A status accreditation, which is normally done by the Global Alliance of Human Rights Institutions, which is guided by the UN guiding principles for the national human rights institutions. It is not easy, but when you are an A status NHRI, it gives you certain leverage to interact in various international fora where we are able to articulate the situation of human rights in Kenya and as well as in Africa. We have also gone on record as an entity that has been very keen on monitoring the rights of persons with disabilities under the UN Crpd Article 33.2 of the convention. And I'm happy we have also reports that can be accessed on our website for information. But I must say that this must be a continuous process, and therefore, since we did the last one, I think it's an high time we also moved ahead and continued undertaking this very noble exercise. This morning, I'm also happy to take note of other very significant happenings in the world today. For instance, when you look at the WHO and the subject we are discussing here today, there are 1 billion persons with disabilities in the world. And when you look at our constitution, Article 260, it gives the definition of disability. And of course, this includes an impairment or a condition or illness that is perceived by many to have a substantial or long-term effect on an individual's ability to carry out ordinary day-to-day activities. And this definition, therefore, when you look at it, is very important as you deliberate in this particular conference, because I know there are different views about disability. There are also others which are being added. Recently, I saw in the US, they have also added even obesity as one of them. And therefore, that tells you that definitions, keep on changing. And therefore, even when these cases appear before our, judiciary, then looking at the definition of what we have in the Constitution and the emerging classification of disability, then it makes the situation very volatile in our thinking and also even in the dispensation of justice. 2019, with our census, it went on record that we have 2.2% of Kenya's population comprising persons with disability. Therefore, as the population increases, the numbers also increase. Therefore, we must think of the strategies, especially to combat discrimination, strategies to enhance access to justice for the growing number of persons with disabilities. That also brings in the question of our preparedness, especially the judiciary. Are we continuously then building, their capacity on the emerging trends of disability for them to be able to dispense, justice? That remains very, very vital for us. Ladies and gentlemen, in our country, Kenya, it is not a question of lack of policies. It is not a question of lack of legislation, but our greatest underdoing is the question of implementation of those policies and the legislation. And this is an aspect we may need to recast our thoughts around, because we are not saying, now let's come up with a new legislation. They are there, but the question of implementation, and most importantly, what I see in our various sectors of government, our attitudes, especially towards inclusion of persons with disabilities, is really wanting. And that reminds us of the question of government laying more emphasis on its approaches in ensuring that inclusion is given its rightful place in our society. Allow me also to say that our justice system has really evolved over time. Our judiciary is recognized globally as one that has stood, the test of times. We are aware of the challenges sometimes the judiciary goes through. I'm not campaigning for them in this forum, but I know, and you have also read in the papers, for instance, challenges around funding, for example, which may impact on the dispensation of justice, personnel, among other, challenges that they face. But as a commission, we are proud that our judiciary has stood firm in the dispensation of justice and using various strategies. Very much aware. As a commission, we are a member of the NCAJ, which also gives us an opportunity, therefore, to engage on matters of human rights and access to justice. Article 27 and Article 28 are very critical for us in these discussions on non-discrimination and, of course, human dignity as well. And Article 29 on freedom and security of the person. I can name quite a number of them, but what strikes us as a commission is what direction then do we take when, say, criminal matters are brought before our judiciary. And I have seen in some of the questions that you raised to guide us in these discussions, is a criminal act complete without the mens rea? Of course, the actors, the judges always look at the actors, yes, it happened, but that aspect of mens rea, and maybe Prof, in academia, as you look through this, those might be insights that we may begin to be reflecting on. Is it complete? And if not, then where is the missing link? And how can then that chain be linked to ensure that there is access to justice for persons with disabilities, and particularly persons with mental challenges. As I conclude, the Commission has worked closely with the Ministry of East African Community, Labor and Social Protection. And in 2015, we developed a national action plan to implement the recommendations regarding the rights of persons with disabilities in Kenya. And we have continuously engaged the ministry to ensure that that plan is fully implemented, and in particular, developing a capacity building strategy within the judicial branch on the human rights of persons with disabilities, including lawyers, magistrates, judges, prison staff, and the police. And therefore, capacity building for us as a commission remains very key, and we call on those who avail budgets to ensure that this aspect is supported across board. Most recently, ladies and gentlemen, you've seen in the newspapers mental challenges, mental illness, and I'm glad we are working with the Senate on a bill. It has really dragged its feet, and I hope Dr. Kabunde will find time to at least illustrate where we are with that. And I do hope that once that legislation is passed at the Senate, it will go a long way in addressing the mental illnesses in this particular country. And we are saying we'll keep on advocating for a hastened approach in having this law passed so that we can deal with it. You have seen our police officers, the challenges they go through. They are very grave. Even in our schools, if we did an audit, I can tell you what the teachers go through handling those very many children. Some of them, our schools, drugs, I can tell you, we have that challenge of drugs in our schools. It is becoming increasingly difficult for our teachers to handle the children. It is very stressful. Unlike maybe 20 years ago when I was in the class and as a high school principal, the challenges we faced then are not the challenges now. The issues of drugs were not as many as they are right now. So how are we helping the children? How are we helping the teachers to ensure that they deal with the problems of drugs? So ladies and gentlemen, I didn't want to bore you with very many words, but today I know you have embarked on a very important conversation, a conversation that is going to highlight a number of opportunities, a number of challenges, a number of gaps that will help us to rethink our approaches as a country towards the inclusion of persons with disabilities. I wish you well in these deliberations, and allow me to thank our partner, the Open Society Initiative for East Africa, for their support to this project, and we look forward to such kind of support to enable us engage further. At a later point, maybe Prof, look for time, maybe have a conversation with the law school so that we also brief you on some of the actions we are doing as a commission, strengthening the partnerships with universities so that then human rights education can be enhanced in our institutions. Allow me to mention one university in this country where we have a running program on human rights education. That is like Kipe University. We have a partnership. We have been able to develop a curriculum on human rights education for all undergraduate students, a module. We are moving towards that in Kisii University School of Law as well. And of course, University of Nairobi, we have a partnership, and we are exploring further partnerships with the higher institutions of learning so that human rights education can be part of our day-to-day life. So that will be in another opportune time to come. So thank you very much. And as a commission, we are proud to associate ourselves with Kabarak University and the partners who are present here today. Thank you very much. And I wish all of us good deliberations as we carry on this particular conference. Mubarikiwe.
Dr. Thank you very much. We are very honored that you came, and with a powerful team in tow. We're very, very happy. with the Commission. I hope we continue to do more, like you've indicated, for the benefit of the people of Africa as a whole. Also to thank you for the steps you have taken to address the issue that I raised, writing to the Chief Justice. I think it's very good that we keep defending each other. We rely on our judges to help us when we're in crisis. We can't abandon them when someone is having a challenge or another. I think I'm really happy with that gesture. Yeah, like I said, we had two shots in the arms, one by the Commission coming to support us, and the other one by Validity Foundation also coming to support us on the other arm. And it's in this regard that I beg you to allow me to welcome Steve Allen, who is joining us virtually. He's not from this country, the co-director of Validity Foundation, which works on this particular theme we're dealing with, the rights of persons with psychosocial and intellectual disability. Steve Allen, are you on the line?
Indeed, I am. Can you hear me?
Yes, we can, very clearly. Please take the floor. We are right here in Kabarak University. As you can see, that background represents the university. And there's a physical audience here. So we are listening both virtually and physically. Feel free and proceed. Thank you.
Many thanks, Chair. And firstly, good morning and greetings from Budapest, Hungary, on behalf of the Validity Foundation. I am very sorry that I cannot be with you in person today, but please let me start by welcoming the efforts of Kabarak University and our other partners in Kenya who have taken the lead on organizing this important and very timely event. I'm also very pleased to hear that there are numerous distinguished and internationally acclaimed guests taking part in these timely discussions on working towards equal access to justice for persons with psychosocial and intellectual disabilities. I particularly want to welcome the involvement of the Kenyan National Commission on Human Rights for their leadership and coordinating role in pushing for genuine reforms, seeking to improve human rights protections for persons with disabilities. And I'm delighted to hear of the involvement of members of the Kenyan judiciary also. Indeed, it seems to me that we are now heading towards a time where a critical mass is emerging in the call for equal access to justice, a call which my organization strongly endorses. Validity is an international non-governmental organization, and we exist to promote, protect, and defend the human rights of people with disabilities in alignment with international human rights law, notably the Convention on the Rights of Persons with Disabilities. We have worked across Africa and Europe for the last 2 decades to challenge some of the most widespread and systematic human rights violations faced by people with disabilities. Indeed, those which create systems of exclusion and social isolation that indeed have a profound effect on people in their lives. In the criminal justice field, many Commonwealth countries retain outdated, discriminatory, and highly restrictive rules and norms which deny people equal access to justice. And I was very interested and pleased to hear in the opening remarks the acknowledgement that we must understand and tackle the historical and indeed the colonial roots of these problems. I could not agree more that we need to together work on a decolonizing approach to reforming our criminal justice systems in order to ensure equal access to justice. What are the problems here? Well, there are a few. Legal rules that refuse to acknowledge the personhood of people with disabilities in criminal proceedings is at the heart of this problem. The judicial finding that persons with disabilities are incapable of participating in their own defense essentially removes them from the protection of the province of law. The effect of such findings are that people are denied due process rights in terms of advancing a defense. They are denied the opportunity to put the prosecution to proof, and they are denied the right to be heard in proceedings that indeed can result in very severe restrictions on their human rights. The second set of issues relates more to the implications of these findings, and findings such as not guilty by reason of insanity. For the majority of us, when we are found not guilty of a crime, that's the end of the story. We can literally walk out of the courtroom free and continue with our lives, safe in the knowledge that our innocence has been acknowledged. But that is not the case for persons with intellectual and psychosocial disabilities. Instead, these people enter a Kafkaesque world, having their liberty restricted, and in many cases, ending up being detained without any judicial oversight at all. They are detained at the so-called presidential pleasure, a term which suggests, of course, that we are subject purely to the whims of those who lead us. It is well documented that these rules result in arbitrary detention of persons with disabilities, in many cases denying their people their freedom for years, decades, or sometimes their whole lives. This problem is not unique to Kenya. It saddens me to acknowledge that this is a global problem, often flowing from deeply discriminatory rules enshrined within constitutional provisions that were drafted during colonial eras. I am reminded at this time that the road to hell is paved with good intentions, and indeed, this is very much the case when we consider the denial of equal access to justice for people with disabilities. Some of these so-called protections were designed to limit the punitive effects of the criminal justice system on people who were regarded as, quote, feeble-minded. It was believed that people with disabilities either shouldn't be published, a deeply paternalistic approach, or that they simply couldn't understand the gravity of the matters that faced them. How can it be right, if this was the intention then, that persons with disabilities can find themselves in such Kafkaesque positions of having their liberty denied and no route to even challenge this? This old approach is deeply discriminatory. It relies on stigmatization and outdated approaches which deny people their dignity, their autonomy, and their human rights. With the adoption of the Convention on the Rights of Persons with Disabilities, it is now crucial that we begin to tackle these historic injustices head on. It is no mean feat to reform our criminal justice systems, but we have a requirement to do so under international law. No more must we start from the premise that people with disabilities should simply be protected or indeed detained. We must be guided by the principle of equality that grounds the Convention on the Rights of People with Disabilities. Many have concerns that putting people with disabilities on trial will actually lead to unjust punishment. Yet, this argument fails to acknowledge the harms that are already visited on people who are denied access to justice and the ability to participate in their own defense. It is crucial, therefore, that our reform efforts are grounded in the rights to equal equality and non-discrimination. This is a challenging undertaking, requiring reform to both legislation and constitutions to abolish those legal mechanisms which reinforce parallel systems of incarceration for people with disabilities. We must give full and equal recognition of the so-called right to legal capacity in the first instance. This is the legal recognition of our equal humanity as guaranteed under Article 12 of the Convention on the Rights of Persons with Disabilities. But this alone will not be enough. We all know that our justice systems remain inaccessible for many people, and this disproportionately impacts on persons with disabilities. So we also need to adapt our procedural rules. Instead of removing people from the criminal justice process, our courts and judges are the people who must provide reasonable and procedural accommodations which enable real and effective participation. Validity is very proud to join with you today in stimulating this important discussion. I'm sure many of these themes will be addressed in much more detail today. It remains for me to say I very much look forward to meeting many of you when we are over this horrendous pandemic. What you are discussing today is of crucial importance to persons with disabilities, not just in Kenya, but much more widely. We very much thank you for your leadership. I hand back over to you, Mr. Chair.
with an attempt to understanding this difficult topic. And we need, Professor, to demystify matters pertaining to mental disability. So many people are suffering, including ourselves. Sometimes you might see me standing here and I could probably be sick. But no one will understand. What they will do is that they'll castigate me and wonder what is wrong with the judge. And what I needed is just 2 minutes away to see a doctor and then, explain to me that, judge, you have overworked yourself, so you're suffering from depression, ABCD, and many others. So it is a very good topic that you have elected, Professor. I'm so delighted. And when I was going through preparation for my opening remarks, I came to learn so much about this topic. That, initially, because we have attempted to criminalize mental disability in our penal laws, elsewhere, people are working very hard to decriminalize mental illness from their penal laws. That notwithstanding, I also stumbled on parts of the law in various jurisdictions where it is now law, and not just law, but practice, that persons suffering from mental disabilities ought to be considered as normal human beings. Because if I'm allowed to work in an office because I do not have one leg, either I was born without it or I suffered an accident, and here I am with a mental disability and you are telling me, get off. Honestly, we need to rethink about it. It's a very sad and dark moment for us. So, Dr. Mogesa, I'm very happy that you have done something. I cannot discuss much because then it becomes a live issue, but I am certain that people who will deal with such issues will come across some of very good jurisprudence to read from and understand that persons suffering from mental disabilities are not abnormal persons. And in their very good moments, let me tell you, they will output and do very good work. Autistic persons, some of us who have grown to be who we are very talented persons. But I will be engaged wherever I am. But in that moment when I have to exhibit my characteristics as such, I will be hooted out of the office. For God's sake, God forbid that that does not happen and that we come more to understand what mental disability is. So I am the chair of the National Committee on Criminal Justice Reforms under the NCJ. And I thank God that he gave me this opportunity, not because I'm special, but because with the work that we have done, I have come across so many things that we need to work through our penal system. So we have done quite a lot of research, Dr. Abani, and as you say that you'd wish that Kabarak University partners with us so that you can publish even some of the work that we are doing research on. We have several publications, and soon, God willing, once we're able to print them, they shall be launched by the Honorable Chief Justice. So we have engaged so many investigators, we have engaged our adjudicators, we have engaged our prosecutors. We have done a lot of research work, the basis on which, Dr. Abani, you have been part of us to draft for us the bills to decriminalize and reclassify our petty offenses. Then just a few days ago, I come to learn that our county government in Nairobi has again legislated these petty offenses. And I said, my God, what the hell is all this? And what am I doing? Because I have thought about this person who is suffering from a psychosocial and intellectual disability, just walking on the streets and urinating and spitting and doing something funny. And the next thing, because he has no one to defend, and he can't also speak for himself, he's hooded into court, he's fined, he cannot pay even that 500 shillings. And so what protects of this person? He remains in custody. So, and as I was sitting with our researcher, Susan, I said, probably we have over-engaged the mainstream prosecutors, the investigators, but failed to over-engage our county government. And I have thought that that is a challenge. I said, that's okay. Let them continue with what they are doing, but in no less few days, I shall have to engage them and tell them you cannot take us now centuries back when we have this bill we are just about to present to Parliament to decriminalize these petty offenses. And what we are doing now is to legislate them. No, we can't allow that. So I'm very happy about this topic. I am so glad that we are speaking to it. And I believe when you come out with your communique out of this conference, you shall be able to speak to so many thousands of us, including us judges, to try and understand this topic otherwise understood by all of us. So I'm very glad to be part of this discussion and to speak to this subject and for us to engage in a very objective manner. So on a lighter moment, Prof, when you requested me to come, I said, wow, this is nice because I've been here previously and I told you only 4 years ago, my daughter left Kabarak High School. Now she's in 4th year university. And I know this is one of the crowds that you mentor good people. So for you who are doing law here, I think you are in the right place. And the professor having come here to mentor these students, I'm sure that something good will come out of what you are doing. So I'm very happy. So allow me kindly, therefore, to make my opening remarks. So I'm informed that the Vice Chancellor will soon be joining us. Allow me to recognize him, Professor Henry Kiplagat, and he shall also be joined by the Deputy Vice Chancellor, Administration and Finance, Professor Ronald Chepkilot. Then let me recognize you, the Dean, Kabarak Law School, Professor John Abani, CEO, Kenya National Human Rights Commission, Bernard Mogesa, Co-Executive Director, who has just spoken, Validity Foundation, Mr. Stephen Allen, and all of us participants, majority of whom are online. Ladies and gentlemen, good morning. Yeah, offline again, I'm sure this would have been a big conference at Adum. We are living in very difficult circumstances, but I know hundreds of us are watching us. So let's accept the situation as it is. It does not demean what we are doing here as few as we are. So allow me to start by expressing my most sincere gratitude to Kabarak University for inviting me to attend and give an opening address during this conference. It is indeed an honor to be here among so many justice sector practitioners and law scholars who share a commitment to enhancing access to justice for persons with intellectual and psychosocial disabilities in the criminal justice system. The National Committee on Criminal Justice System, reforms, commonly we refer ourselves as NCCJR, shares with you in this commitment. NCCJR is a multi-agency initiative established as one of the thematic committees under the National Council on Administration of Justice, NCOJ. Its establishment followed a raft of recommendations in a research conducted by Legal Resources Foundation and Resources-Oriented Development Initiative, RODI, in conjunction with NCOJ on problems that inhibit and impede a proper delivery of justice in the criminal justice sector, that is CJS, in what is now commonly known as the audit report. The committee is mandated to spearhead comprehensive review and reform the Kenya's entire criminal justice system under its 10 terms of reference. And I will just mention few which are key and can speak to the topics that we are discussing in this conference. Number one, the identification of the legal, institutional, and administrative barriers impeding the efficient functioning of the criminal justice system and formulation of workable solutions. Two, the identification of laws and policies criminalizing petty offenses and development of recommendations geared towards their decriminalization and reclassification. Three, the comprehensive review of Kenya's penal laws. And number four, the design and establishment of mechanisms to ensure that Kenya's criminal justice system operates in a manner consistent and compliant with the provisions of the Kenyan Constitution 2010. Ladies and gentlemen, over the few years, mental health and well-being has become an area of great concern in Kenya. According to a report released in 2010 by the Ministry of Health, Task Force on Mental Health, one of every 5 Kenyans is likely to suffer from a mental illness within the lifetime, including yourselves, including myself. So today, one can only imagine the impact of the COVID-19. People are suffering quite a lot. Depression, and no one to speak to. It is having a great impact on our mental health. Of great concern and worth noting is also the increase in the number of suicide cases in the country. So that speaks volumes. The statistics shared recently by the Directorate of Criminal Investigations, DCI, and this was discussed on the 12th Parliament 5th session votes and proceedings on Wednesday, 4th of August, 2021, indicate that 3 months between April and June 2021, at least 483 people were reported to having committed suicide. That is only 3 months. We have 12 months in a year. This is more than twice the number of people who were reported in the entire year 2019, as reported by the Kenya National Bureau of Statistics. Majority of Kenyans do not have sufficient information to enable them to identify the signs and symptoms of mental illness, or how to go about assessing professional health. For us as actors within the criminal justice sector, issues concerning mental health and how to handle persons with mental illness are some of the most challenging and most ununderstood. So then, how fitting is it therefore that the theme of this year's conference focuses on access to justice for persons with intellectual and psychosocial disabilities within the criminal justice system? Let me try and explore something small here to try and answer this question. So the Persons with Disabilities Act 2003, under Section 38, creates an obligation on the Attorney General in consultation with the Council and Law Society of Kenya to develop regulations ensuring the provision of free legal services to persons with disabilities. This council is established under Section 3 of the Act, so you can read about it. So in the year 2008, Kenya ratified the United Nations Convention on Rights of Persons with Disabilities, CRPD, which under Article 13.1 creates an obligation for state parties to ensure effective access to justice for persons with disabilities on an equal basis with others, including through the provision of procedural and age-appropriate accommodations in order to facilitate their effective role as direct and indirect participants, including as witnesses in all legal proceedings, including investigative and other preliminary stages. In order to ensure effective access to justice for persons with disabilities, state parties also required to promote appropriate training for those working in the field of administration of justice, including police and prison staff. With the entry into force of the Kenyan 2010 Constitution, an obligation was created on all state organs and public offices to address the needs of vulnerable groups, including persons with disabilities, see Article 21. With specific reference to persons with disabilities, Article 54 guarantees them the right to be treated with dignity and respect, and not to be addressed or referred to in a manner that is demeaning. Other rights of particular significance include right to equality and freedom from discrimination, referred to Article 27, the right to have their inherent dignity respected, Article 28, the right to freedom and security of persons, in particular, the right not to be subjected to physical and psychological torture or to be treated or punished in a cruel, inhuman, and degrading manner, Article 29. The right to the highest attainable standard of health, Article 43. Access to justice is guaranteed under Article 48 And a number of rights have also come to be of particular significance to persons with intellectual and psychosocial disabilities within the criminal justice system. Article 49, on the other hand, comprehensively establishes the rights of an arrested person and includes in particular the rights of an accused person to be informed promptly in a language that the person understands, the reason for the arrest, the right to remain silent, and the right to communicate with an advocate or other persons of assistance if necessary. Under Article 50, there is comprehensively established the right to fair hearing, which includes the right to be informed of the charge with sufficient detail to answer it, the right to speedy trial, the right to have advocate assigned to the accused person by state and the state at state expense, where substantial injustice would otherwise result, the right to have assistance of an interpreter without payment if the accused person cannot understand the language used at the trial, the right to have all information given to a person in a language they understand, and in the interest of justice, a court may allow an intermediary to assist a complainant or an accused person to communicate with the court. And this usually applies to vulnerable persons. With particular reference to victims of crime, Section 4 of the Victim Protection Act 2014 mandates courts, administrative bodies, and persons performing any function under the Act respect and uphold the values and principles of the Constitution aforementioned, and ensure that every victim is addressed in a manner appropriate to their age, intellectual development, and is spoken to and allowed to speak in his or her language of choice or through an interpreter if necessary. So then, what is the reality on the ground? I've already emphasized the rights and protections provided in various legislative instruments and our Constitution so as to demonstrate the stark contrast that exists in practice. Persons with intellectual and psychosocial disabilities still continue to face numerous barriers in access to justice with the criminal justice system. To state briefly some of the barriers identified by us, the committee, during the course of our work, which Professor Bear has witnessed, include the following. Number one, there is inadequate awareness and understanding of mental health issues within criminal justice system. To this, many key actors within the criminal justice system, including the police, defense advocates, prosecutors, judicial officers, correctional officers, do not have adequate understanding of intellectual and psychosocial disabilities. This has a negative impact on the manner in which laws around the issue are implemented, making it difficult for vulnerable victims, witnesses, and offenders to access justice. Number two, criminal laws governing the manner in which persons with intellectual and psychosocial disabilities are processed through the criminal justice system do not embody the rights and protections reflected in the Constitution. I give an example of Section 167 of the Criminal Procedure Code. The same provides that where an accused who is not, and I've put both apostrophes on both ends, insane, because this is derogatory, and we'll speak to it later, cannot be made to understand the proceedings of the court, is of the opinion that the evidence would justify a conviction, it shall order the accused to be detained during the president's pleasure. Another very thorny issue. Aside from the derogatory manner in which this provision refers to persons with intellectual disabilities, the application of this law has resulted in the unjustified and prolonged detention of many people in our correctional institutions. The courts have declared Section 167, referred to there before, unconstitutional in the case of Hassan Hussein Yusuf versus Republic 2016, EKRL. EKLR, and Joseph Melicano Katuta versus Republic 2016, EKLR. The courts have emphasized that keeping a mentally ill person in prison at the pleasure of the president for an indeterminate period of time amounts to cruel, inhuman, and degrading treatment that violates Article 25 and 29 of the Constitution. So we need to applaud our judiciary, speaking so loudly and so broadly. So criminal laws still use derogatory terms, unfortunately, and that is part of our mandate. And in our proposed bills, we have had to propose other names other than this insane and disabled and what have you. Terms when referring to persons with mental illness, further advancing their stigmatization, definitely. So the Penal Code uses derogatory language under Section 146 for referring to persons with intellectual and psychosocial disabilities as idiots and imbeciles. You know? And they did not choose to be who they are or to be born how they are. So we must delete these terms from our laws. Yeah, that is biggest, one of the big challenges we have, but thankfully we have the bill and this may be a thing of the past. So criminal law penalizes attempted suicide. We all know this. So our Penal Code automatically punishes persons with attempted suicide under Section 266 without taking into account the fact that suicidal behavior may be the result of an underlying mental illness or psychosocial or psychological trauma. Because it is a misdemeanor, the prescribed sentence is captured in Section 36, which is a payment of a fine or imprisonment for a term not exceeding 2 years or both. Yet, the more appropriate rehabilitative option would be to refer the person to appropriate treatment, such as psychological counseling, psychotherapy, or participation in suicide prevention programs. I believe so, and you know that, isn't it? Yeah. So something must be done now. So thirdly, the criminal justice system heavily enforces petty offenses. Persons with intellectual and psychosocial disabilities represent a disproportionate number of the people who are processed through the criminal justice system for committing offenses such as causing a breach of the peace or for indecent acts penalized under Section 182 of the Penal Code, as well as county legislation. I have already mentioned about it. So we have proposed in our bill to entirely delete this section from our Penal Code. So there, number 4, there is inadequate access to legal aid services for persons with intellectual and psychosocial disabilities. The Persons with Disabilities Act 2003, under Section 38, creates an obligation on the Attorney General in consultation with the Council. This is National Council for Persons with Disabilities, established under Section 3, and the Law Society of Kenya to develop regulations ensuring the provision of free legal services to persons with disabilities. Yet, to date, access to legal aid services for these persons is largely out of reach for persons with the intellectual and psychosocial disabilities. And why? Because they cannot speak for themselves. It is noteworthy, therefore, to mention that the Legal Aid Act 2016, under Section 36, categorizes persons eligible to receive legal aid services to include indigent residents in Kenya who are citizens, children, refugees, victims of human trafficking, internally displaced persons, or stateless persons, but makes no mention to persons with disabilities. Isn't there now time for us to ensure that the Act itself is amended to include persons with mental disabilities? So fifthly, one of the problems that we have identified is there are numerous gaps in practice with regards to the procedure of handling persons with mental illness within detention facilities. Practice appears to be inconsistent in dealing with inmates presenting with mental illness in various correctional facilities across the country. The common practice, owing to inadequate infrastructure, is to house persons with mental illness in a separate block of the prison or in hospital section, separate from the general population. Inmates presenting with more serious cases of mental illness are referred to psychiatric hospitals. However, resources also influence the speed with which appropriate treatment can be rendered. And so they remain in those blocks or in the hospital for too long without trial. Number 6, the general conditions of detention for mentally ill offenders at Madarim National Referral Hospital, Maximum Security Unit. As you know, initially this hospital was called the Madarim Mental Hospital. Of course, now it has grown to be a National Referral Hospital. However, the maximum unit still remains for those persons who are facing trials and are said to have the mental disabilities. I have personally visited that unit. I do not think it is an institution that any human being can be condemned to live in. Roofs are falling, sanitary conditions are wanting, the personnel ratio to the persons who are detained there is very high. Others have gone on without trial for so long because you see, if you look at the CPC currently, and which I believe we shall have a discussion on at the panel, is that you keep this person at the president's pleasure. And until such a time that this person is first brought to court for mention to confirm whether or not they can start trial, they remain there condemned. Others have been convicted, guilty but insane, but still at the president's pleasure. And they have been there for tens of years. Others are aged. And then what the hospital has done is that a few of them have tried to connect them with their backgrounds, their families. But to the family, again, and allow me to use the same word, they are insane. You know, the mental disability. And so they do not want them. So they say, we don't want that person. It's better in that block, in that hospital. So they are aged shows there. It is a very pathetic case. So really, there's a lot that requires to be done. And I will mention hereafter what recommendations we have made to arrest this situation. So the holding facilities are dilapidated and the staff to patient ratio is very high. The pace at which the power of mercy is being administered is low. Therefore, many offenders remain in the MCU, that is Maximum Security Unit, long after it is recommended that they be released at the power of mercy. There are also no halfway homes established by the state to accommodate those who qualify for release and are rejected by the community with stigma. Number 7, there is inadequate access to psychosocial support services for actors within the criminal justice system. The various actors within the criminal justice system often handle high risk and stressful assignments. With inadequate access to psychosocial support, these actors, they often experience high levels of stress. This can lead to depression and substance dependency, which may in turn affect the quality of services rendered, you know, exacerbating the situation, which is already bad in the first instance. So it is against this background that the committee proposes a number of recommendations geared towards reform. A few of the recommendations which I'll mention here, because we cannot talk about ISCCJR unless we have 3-4 days. Now, but with respect to this subject, we have recommended a few things. One, the amendment of the legal framework governing the manner in which persons with intellectual and psychosocial disabilities are processed through the criminal justice system. To this end, and towards the realization of its mandate, NCCJR has greatly benefited from its engagement with Kabarak University's Dean School of Law, Professor Abani, who is with us, who has worked very closely with the committee in the research and development of amendment bills seeking to address gaps identified in the law and align the statutes with the provisions of the 2010 Constitution. Of course, including, for instance, the deletion of offense of suicide and the removal of some of these derogatory. We recommend the development of comprehensive guidelines which ensure that the unique circumstances of persons with mental illness are recognized, respected, and accommodated within the criminal justice system. In particular, the guidelines should address A, the institutions of CJS can work collaboratively with the management of victims, witnesses, and offenders presenting with mental illness so as to ensure reduction of delays in court processes, speedy assessment, access to appropriate treatment. B, how petty offenders suffering from mental illness are to be handled and diverted to the appropriate community-based mental health treatment programs as an alternative to punishment. But of course, we are not saying that there's not legitimacy justification to punish some of these petty offenses. But honestly, it is not through the mainstream justice system. Urinate, I can ask you, just sweep this office and go, if you are not one of those persons who suffer from a disability. Those are some of the things that we are trying to address. Number C, the standard procedure on how prisoners with mental illness across all correctional or detention facilities are identified, managed, referred to appropriate treatment facilities or programs, and returned to the prisons or remand facilities after treatment to start trial or continue serving their sentences. Because you see, once you say you are remanding this person at the president's pleasure, so until when? There must be a framework through which these persons continue to come to court for us to assess as court, not the president. And we have said this is judicial function. As courts, to further recommend based on medical reports that this person continues with the trial or discontinues with it. And you know, I read one of the case laws in the UK, and they said because it still is applicable in our Kenyan statutes, that yes, you killed the person. So the killing, the actus reus is there. But somebody mentioned about the mens rea yourself. If it is lacking, how do you then enter a verdict of guilty? It cannot happen. And so the House of Lords was agonizing itself because then the provision was as is in our Kenyan system, guilty but insane. And they said no. If he committed the offense at a moment when he was mentally disabled, how did he possess mens rea? Did not. The program, no doubt, shall enrich all participants with the knowledge and interact with what we need to learn in this otherwise not so well understood topic, ranging from applicable international standards, local regional standards, and the law, policy, and practice in Kenya. I am upbeat personally that we shall at the this conference have learned more, and we shall be more enriched in the program than we came. Each one of you for your attention, and finally allow me, as is my senior international law conference and intellectual disabilities in the criminal justice system open. Thank you very much, and God bless you.
I think we can have another round of applause. Because from where I sit, she touched on the real things for me, on the reforms that we need to do. And we are in a good place because Judge is chair of the Criminal Justice Reforms Committee that is doing all. Like Dr. Mogesa, your institution, I think, is always there to support the human rights mandate, the public, the universities. And then I think, Judge, you can count on us. Dr. Mogesa, you can count on us as Kabarak Law School. We will always be there to research, to debate, to educate. We will work together on these things. I think that's the only way forward. But I'm really, really quite excited that we begin the conversation on this high note after those remarks. Our VC will also join us later to support the statements you've made and obviously to welcome you home. But as that happens, we can start the conversation. And allow me to invite Luciana Thuo, who is the head of this whole program, to take us to the next level. Thank you.
Thank you so much, Prof. Thank you also, Lady Justice Nganya, for those remarks. I believe we are all excited to now go into the meat of the discussion, isn't it? So we'll have a brief session with two participants who will be joining us virtually. We'll have Professor Flynn and Dr. Gooding, who will be joining us for the discussion. Then we'll take a brief health break, and then we'll continue with the rest of the program. The session chair for this particular session is Dr. Elizabeth Kamundia, who's the Assistant Director from KNCHR. She's also the focal lead on disability rights. She'll be taking us through this session. So I'll invite Dr. Kamundia to come and take over.
Good morning, everybody. Welcome to this international conference on access to justice for persons with psychosocial and intellectual disabilities in the criminal justice system. This session that we are currently in is titled International Standards, and what we are aiming to do is to get at perspectives that will shed light on how countries around the world are dealing with certain contentious aspects pertaining to persons with psychosocial and intellectual disabilities in the criminal justice system. And I am delighted to usher in our panelists, some of whom I have had the singular pleasure of working with before. Our first panelist is Professor Eleanor Flynn. Now, Professor Flynn is an established chair in law and director of the Unparalleled Center for Disability Law and Policy of the National University of Ireland in Galway. Her research focuses on disability and social justice with a particular emphasis on legal capacity, advocacy, and reproductive justice. She has published widely and has acted as a board member and advisor in a range of local, national, and international bodies working on the rights of disabled people, and regularly advises policymakers at national and international levels, including providing support to the Secretariat of the UN Committee on the Rights of Persons with Disabilities, and in particular, the working group, which developed the General Comment number 1 on equal recognition before the law. Our presentation today is Disability in the Criminal Justice System, from Neutrality to Transformation. Welcome, Professor Flynn. You have the floor.
Thank you very much, Elizabeth, for that introduction, and I'm very pleased to be joining you today.
We can't hear you.
You can't hear me? Okay, let me try without this mic. Can you hear me now?
No,
Still?
not yet.
Okay. Not sure if there's anything else I need to do to make sure that you can hear me. Still no? Oh, okay. Piers is saying you can hear me online, but maybe not in the room. Okay.
Yeah, we are
So just-
expecting the audio.
Okay. Can you hear me now?
Not yet.
Okay. Always the problems with technology and the opportunities it gives us. So hopefully we'll have the audio resolved in a moment.
Eleanor,
Yes.
let's give it 2 minutes as we try
Okay.
to sort it out on our end, then we'll proceed.
Okay.
Ladies and gentlemen, as we're sorting out the audio on our part, because it seems the problem is ours, we have now been joined by our Vice Chancellor, Professor Henry Kiplanga, and Pilots. And so because we have been graced by their presence, I'd like us to give them a few minutes to make us their remarks as we are sorting out the audio on our part, and we'll resume with a substantive presentation. I hope that's okay. Yeah, okay. Prof. Kiplanga, we are always grateful for your support, and we're always grateful to have you join us during our event. Allow me to usher, would Prof. Chapilot also be saying something? Okay. All right, I'll usher you in then to make your opening remarks. We have a problem with the audio, and so as we are sorting out that audio, we thought it would be prudent to allow you to address us. We've been eagerly waiting to hear you. Could we? All right, Prof. Ambani.
Thank you, Luciana. Like we had promised, our Vice Chancellor has come. Most of you had asked me yesterday or evening about the vision. You believe that there was a good vision, which is true, and that there was a good stewardship in Kabarak, which is why you are happy with the facilities here. And I even promised that today I will take you to the real place, the university. The only reason actually we didn't do the forum there was because we are receiving first years, about 2,500 of them, and their parents and excitement. We thought that it could, we could also join that joy and forget the conference. So we moved here. I will take you there, and I'm sure you will have very good view of our university. But just to say that the stewards, the real people that have made this school as good as it is, are actually here now. And I'm so excited that they have joined us. Judge, you also mentioned that your daughter went to Kabarak University, Kabarak High School. The brains behind it are here as well. So we're quite excited to be joined by them. The VC has been giving all the support to the law school, has been attending all the forums the law school does, and we're always very excited to enjoy that kind of support. We are actually the deep state of this part of the world as a law school, because we are enjoying all that support from the university administration, and which is why you can see the results. The good fruits you're seeing today are part of that success. Allow me to invite our Deputy Vice Chancellor, who I work with as my supervisor in the area of administration.
Chief Executive Officer, Kenya National Commission on Human Rights, the guests who are joining us virtually, the participants of this workshop, ladies and gentlemen. Good morning. I'm delighted to be part of this workshop, which is on the access to justice for persons with psychological and intellectual disabilities in the criminal justice system. I wish to thank the Dean and his team for spearheading this conference, which comes at a time when there is a national debate on mental disabilities or psychological issues, which is an issue that cuts across all sectors in Kenya, and of course affecting the citizens and the people of Kenya. And so this discussion is coming at a time when there is a lot of focus in this area. I think we are now realizing that this mental illness is widespread, and we had not considered it a challenge as a country, but I think it's receiving all the attention. And wish to thank also the Vice Chancellor for providing resources and time for this conference. I think as a university, we have a strong commitment to the advancement of knowledge. And that includes research and also dissemination of the same. I'm sure there are many research papers or findings that would be disseminated as far as this discussion is concerned. And so our Vice Chancellor to address this conference. So welcome, sir. Professor Henry Kibla, let's give him a clap as he comes.
Our Chief Guest of Honor, Honorable Lady Justice Grace W. Ngenye, Judge of the High Court, Kenya. Mr. Bernard Mogesi, is it Mogesa? I thought you told me doctor. Doctor, so you are misleading me, sorry. You are forgiven, you will not be jailed, the judge is here. Dr. Bernard Mogesa, the Chief Executive Officer, Kenya National Commission on Human Rights. Mr. Stephen Allen, the Co-Executive Director of Validity Foundation, members of the University Management who are present here, the Dean of School of Law, Professor J. Osogwambani, members of the civil society, members of the Kabarak University staff, students, distinguished guests, ladies and gentlemen, good morning. It is my pleasure to welcome you to Kabarak University, and specifically to the 4th International Kabarak University Law School Annual Conference. This year, of course, we have a conference and you're here. And in this conference, we have a theme that the DVC mentioned. And I would like to say that this year's conference and its very theme come at an opportune moment in the history of the Kenyan people and that of the world at large. Ladies and gentlemen, we live now in the wake of a world shaken by the COVID-19 pandemic. And while we are all fighting to restore normalcy, we have also had to acknowledge that there is no going back, at least at the moment, to the time before, a world of certainty and predictability. Prior to COVID-19, we knew we would do this. We would be in a conference. We didn't have to block our mouths and cover our noses, and even sometimes confuse the way we look like. But now, I may not even recognize my friend until I ask my friend to remove the mask. So that world is gone, but we hope that we shall return to normalcy. We hope we will get to a world of certainty and predictability again, a world that one would take for granted or even treat with indifference the mundane things of life, the simple fact of breathing, or the basic reality of human dependency, how we must hold each other up at least lest we fall. So we must hold each other unless we are not ready to stand together. So indeed, ladies and gentlemen, this pandemic has age old adage or charge that we must be our brothers and sisters keeper. We must care not only for each of ourselves, but also for those around us that have been marginalized and stigmatized. Those for whom the precarity now exposed by the pandemic has long been a part of their lives. And surprisingly, ladies and gentlemen, with most of us having been secluded, living with the anxiety of these times, the pandemic has also ushered the mainstream the conversation on the importance of mental health. Thus, this conference comes not a minute too late. This conference aims to shed light upon the place of a group of persons that have been living through a pandemic of their own, silenced in the shadows, stigmatized for their difference, for intellectual and psychosocial disabilities. This same discrimination has been reflected in the law and the criminal justice system in particular with saddening consequences. It is my hope, our chief guest, distinguished guests, ladies and gentlemen, that they create the much needed platform for us to have an honest dialogue about these often forgotten persons in our society, the persons with intellectual and psychosocial disabilities. Sometimes when we meet these people, even in the streets or around us, you tend to shun them. You run away from them. We forget sometimes that they are humans like us. 2 weeks ago, I saw some little boys and girls in one of our neighboring schools who are in the scouting movement. We just went to the center to attend to someone who had these psychosocial problems, someone who had mental challenges. And these little boys in primary school and girls were able to provide food to that person and even buy clothes. I was so impressed. I hope those ones will be lawyers so that they can take care of such people within the criminal justice system. And they are becoming many in society now. So I believe that with the vast experience and expertise of our panelists, these deliberations will undoubtedly put us on a sure path towards securing the dignity of persons with intellectual and psychosocial disabilities in the criminal justice system, as well as in society in general. It is my hope that through the conversations that you'll have today in this conference and the days to come, perhaps even as a country, our programs shall be shaped to take care of these people. I know in the legal world, maybe you take care of them because you are the only people who are learned in this world. Everybody has not gone to school, even myself who claim to be a PhD holder. According to lawyers, I'm not learned. I don't know what I am, but I hope, honestly, as a country, we need to think about keeping, having resources even to take care of these people and even have homes for them. Professor Ambani, I do not know whether I'm off point because you are dealing with people in society. These people are in society, isn't it? So I'm sure something can come out of this conference for the future. well-being of those with intellectual and psychosocial issues. So as Kabarak University, we are proud to be at the forefront in championing such discourses of pertinent relevance to the public good. And by so doing, we seek to ensure that courses offered in our various schools are anchored on a solid understanding of the immediate and long-term needs of our society. And in this way, we ensure that our faculty and students are not simply involved in research for the sake of itself, but are instead interacting with the problems that bedevil our society while identifying practical and homegrown solutions. I wish to take this opportunity to commend the law school for organizing this conference and its related activities. Professor Ambani and your team, Associate Dean, the faculty and the students, I want to commend you on my own behalf and on behalf of Kabarak University Management for this conference. Ladies and gentlemen, this is the second international conference hosted by the School of Law, Kabarak University School of Law, this year alone. So I can see that learned people don't appreciate each other. They don't like clapping. Thank you very much. So you may need to cross over to our side so that we can teach you how to appreciate each other. So thank you very much. I wish to thank our partners who agreed to support this event in different ways. In particular, I wish to express my sincere appreciation to the Kenya National Commission on Human Rights and Validity Foundation. We are grateful to all the participants who honored our invitation to participate in this conference and look forward to the discourse that will flow from the proceedings. To our students, and where are you, by the way? Are you here? Can you stand? To our students, I'm addressing you now. To our students, these are representatives. I'm sure we don't have only 3 students in the School of Law. They're online. So to you, our students, I wish you all the best. I hope you will be able to enrich your study experience through this auspicious event. And there are only 2 good students who kept standing faithfully. Thank you very much. There's one who sat down. But others are here, sorry. Thank you very much. I appreciate you, and please take a seat. So once more, I wish to welcome all of you to this conference and to declare this conference officially open.
I think we can do better in terms of giving a round of applause to our Vice Chancellor. Thank you so much. I think Prof had already mentioned this earlier, but we are very grateful because we receive a lot of institutional support as a law school. We would not be here without that institutional support, and therefore in honor of the presence of the Vice Chancellor and all the other guests who are present, we thought it would be important that we take a photo with the team just here at the balcony, and then we will come back and continue with Dr. Flynn's presentation. So may I kindly ask that we move quickly just to the balcony. We'll take a group photo. And then we will take our proper health break outside. Kindly indulge me as we do this. I know we will take a break now, but we would like to hear from Dr. Flynn, who is not able to join us after the health break. So kindly indulge us. Let's move to the balcony quickly. We'll take a brief photo shoot, then come back and continue with the session. Thank you very much. believe we're now able to hear Professor Flynn. Professor Flynn, are you with us?
I hope so anyway. Can you hear me? Did that work? Can you hear me this time?
Yes, we can hear you.
Great.
Fantastic. Thank you so much for your patience, and we're sorry for the technical hitch. I believe you're able to continue with the presentation now. Kindly go ahead.
Thank you very much. So thanks again to all of you for inviting me to participate in today's event. It's a great pleasure for me to be joining you virtually and together with my former colleague, Dr. Gooding, who's going to speak after me. I hope that we can share some examples from our experience globally of how to address the challenges that you're facing in your context. So I have titled this talk, Disability in the Criminal Justice System, from Neutrality to Transformation, because I think we are perhaps beginning, as you discussed earlier with your bill, in removing archaic language, in abolishing concepts that are not in keeping with the human rights of disabled people. And so we sometimes speak of this as making laws disability neutral. But I think we need to go much beyond this if we are truly to achieve the potential of the UN Convention on the Rights of Persons with Disabilities. And we need to think about transformation in terms of our criminal justice system as a whole. So just a disclaimer to begin, as we all know, the criminal justice system by its nature is reactive rather than proactive. So if we are serious about addressing the harms that are caused, which we use the criminal justice system to address in part, we need to be aware of and we need to be proactively looking beyond the criminal justice system for solutions. Because when people with intellectual and psychosocial disabilities cause harm to others, and of course it does happen like with any other group in society, the ways in which we address those harms and repair those harms, the criminal justice system will never be sufficient to do that. And we know that already from the experiences of people who have been harmed by others who have gone through the criminal justice system to achieve a resolution. And even when the system is working as it should, it is still not possible to address the harms fully in this way. So I just want to acknowledge that at the outset. I'm not going to say much here about our human rights obligations. Justice Ngene has already explained, particularly Article 13 of the UN Convention on the Rights of Persons with Disabilities, which of course encapsulates the right to access justice for all persons with disabilities, including persons with intellectual and psychosocial disabilities. But I just want to bring our attention also to the fact that we now have adopted United Nations principles and guidelines on access to justice, which was a project of the former UN Special Rapporteur on the Rights of Persons with Disabilities, Catalina de Vandas, which myself and my colleagues in Galway supported from a research perspective. And I would encourage you, as you continue to draft your bill and discuss it, to have reference to those principles, some of which have quite practical applications and may be useful to you. I want to just finally highlight in terms of our human rights obligations here, this sentence from the UN Committee on the Rights of Persons with Disabilities guidelines on Article 14, which are on, of course, the right to liberty and security. So here we have a statement that, like persons without disabilities, persons with disabilities are, apologies, I seem to have lost my presentation momentarily. I'm not sure if you can still hear me. I am going to try to fix this part of the presentation.
Flynn, we can still hear you.
Okay, wonderful. Can you still see the presentation?
No, we've lost it.
Okay, let me see if I can reshare it. Okay, I will start with it again. I can. Okay, my apologies. I need to do something to reopen that part of the presentation. So I'll return to that. But again, the key message here is that, of course, when persons with psychosocial or intellectual disabilities commit criminal offences, there is a criminal justice system designed to respond to this. And we must ensure that all of the due process safeguards that are available to all accused persons in the criminal justice system continue to be available to disabled people, no matter what the offence that they have allegedly committed is. And I think that's very, very important to ensure as you go through the reform of the criminal justice system. So if I move on until I can restart my presentation. Oh, I think it's coming back now, just a moment. I should be able to share it here. Okay. Okay. I think there is a different presentation on the screen at present, so I'm going to remove that one if that's okay, and then add mine again. Apologies for delay. I'm not sure why. Ah, okay, here we go. Okay, so yes, okay. So the point of the guidelines statement I wanted to refer to was just that we need to be wary of any diversion of people into a different track or separate system, like the use of mental health laws commonly have a lower standard when it comes to human rights protection and are incompatible with Article 14 of the UN Convention. Okay, so if I can move onto my next slide. Okay, so here, apologies, I want to, in my remaining time, briefly address 4 main areas of concern for criminal justice reform, starting with the insanity defence, moving to fitness to plead or fitness to stand trial, which again, my colleague Dr. Gooding has a lot of experience with a specific project on, and I'm sure we'll talk about that in more detail, and procedural accommodations and diversion, and I will briefly touch on each of these. Okay, so the insanity defence, this takes different forms in different jurisdictions around the world. It may be guilty but insane, as we have discussed previously. It may be, as it is in my context, not guilty by reason of insanity. But whatever the form it takes, the convention is clear, and the UN committee that monitors the convention has clearly called for its abolition, because it says that this constitutes direct discrimination on the basis of disability. So the question is, can it be done? Can we simply abolish the insanity defence? And the answer is yes. For example, 4 states within the United States of America have effectively abolished the insanity defence: Montana, Idaho, Utah, and Kansas. And last year, the US Supreme Court upheld the ways in which Kansas in particular had abolished or had changed the insanity defence to focus only on mens rea, or the intention of the accused person at the time of the crime, rather than on whether or not somebody understood that their conduct was morally wrong. So they removed any requirement that you understand that your conduct was morally wrong as a defence, and instead, if you have the required intention, then you would be found guilty. And the US Supreme Court said that that was not a violation of the individual's due process rights. So it is entirely constitutional in that context not to have a separate insanity defence. So what replaces it? If we remove the insanity defence in its entirety, then we can instead, as of course Justice Ngenya already spoke about, we can focus on mens rea, or the intent requirement. So in many situations, the person who was in a state of emotional crisis or distress at the time that the crime was committed did not understand what exactly they were doing, and therefore would not necessarily have the mens rea to be found guilty of that crime. So that means that the outcome from abolishing the insanity defence is that where there is sufficient intent then we will convict the individual, but without it, the individual must be acquitted. And that is the difference. When we have something like the insanity defense, we typically, if the person is found not guilty by reason of insanity, they will, instead of being, I suppose, undergoing a penal sentence, for example, in a prison context, the individual is often sent into involuntary treatment in psychiatric detention. And what abolishing the insanity defense means is that we are no longer allowed to do that. We must acquit the person, and we cannot mandate them to undergo involuntary psychiatric treatment. We can offer treatment, we can offer different options and supports to the person, but if they are acquitted, and if we are to take the criminal justice system at its word, then acquittal must mean acquittal and not a different kind of detention in an analogous system. So that's our challenge. Are we prepared to do that? But the answer is that it certainly can be done. Okay, so moving then on to fitness to plead or stand trial. So again, we have a requirement from the UN Committee on the Rights of Persons with Disabilities that we abolish these systems if they constitute either direct or indirect discrimination against persons with disabilities. So in many systems around the world use a formulation of what began in England as the Pritchard Test for fitness to stand trial. And while the Pritchard Test talks about the person being under a disability, and it also talks about, need in the English law now, as it has been codified, it involves a medical practitioner, two registered medical practitioners confirming that the person is unfit to stand trial, having done a medical evaluation of that person. I would argue that the steps within the test in terms of what the person must understand in order to be able to participate in the trial are probably capable of being reformulated, at least in a disability neutral way. Now, of course, we would need to pay careful attention to any such reformulation to ensure that we are not just indirectly discriminating against disabled people by continuing to disproportionately find them unfit to stand trial if they have a certain diagnosis like an intellectual or psychosocial disability. But again, let's look at these criteria and think about, these are things that we would want an accused to be able to do. And there are reasons beyond disability why someone might not be able to stand trial if they cannot do the following things. So under the Pritchard Test, the accused would be unfit to plead if they're unable to comprehend the course of proceedings of the trial so as to make a proper defense, if they do not know that they might challenge any jurors to whom they may object, if they are unable to comprehend the evidence against them, or unable to give proper instructions to their legal representatives. So again, and within this, of course, the accused also must be capable of making a plea, so pleading guilty or not guilty. So what's the outcome if we reformulate these criteria in a disability neutral manner? Well, then again, if we find the person is unfit to stand trial for whatever reason, and again, I would suggest we need to think about making available different kinds of evidence and moving away from strictly medical evidence in this context, we have to release them. We cannot proceed with the trial. What we currently have in many contexts is what's called a trial of the facts, which takes place if the person is unfit to stand trial in the proper criminal justice system. And as a result of the trial of the facts, again, the person is often detained in the psychiatric system. So if we are serious about moving beyond this and taking a disability neutral approach as a first step, we must also ensure that, again, just like with the insanity defense, that the person does not end up in involuntary psychiatric treatment. If they're not fit to stand trial, then there can be no trial, and we can offer support, we can offer treatment options or other options to the person, but we cannot force them to take them up, because that is not the role of the criminal justice system. Okay. So I'm moving on again to procedural accommodations. And here, again, the UN Committee on the Rights of Persons with Disabilities has called for these to be provided. And we have heard about how they are part of the obligations we have under Article 13 of the Convention already. I think it's interesting that in Article 13, these are referred to as procedural accommodations, and the term reasonable accommodation is not used. And together with Anna Lawson, I have previously argued that that means that these accommodations must be made available and that they're not bound to the standard of reasonableness, which other reasonable accommodations within the convention are. And because in the criminal justice system, the stakes are so high, the individual's liberty is at stake here, it is really essential that whatever accommodation the person needs in order to participate is actually provided. And we don't look at things like how expensive it is to provide that accommodation. We have to provide it because it is in the interest of justice to do so. So can we do this? Yes, of course we can, but where do we start? How do we know what procedural accommodations must be offered in the trial? Of course, every defendant is different and will have different needs. And of course, different experiences of disability as well. But if we were to start here in imagining what these procedural accommodations could include, I would suggest we start with any procedural accommodations that are currently available to disabled victims or witnesses in the criminal trial. So, for example, in England and Wales, the introduction of registered intermediaries to support disabled victims and witnesses to communicate when giving their testimony in the criminal trial was introduced, but that same thing was not introduced for defendants until much later. However, it did remain within the discretion of the judiciary to have such a process in place. So a judge could ask that for example, if a defendant was taking the stand, that they would have the same right to an intermediary. That could be a sign language interpreter in some contexts. It could be different kinds of communication support depending on how the person communicates, and making that available to the person during the trial, but not just when the person is giving testimony. That is also a really important support for the person in communicating directly with their legal team, for example. So and of course, we should reach a point where all lawyers have sufficient training that they can communicate well with people with intellectual and psychosocial disabilities. But we know the reality right now is that many lawyers have no training on this and are not well placed to communicate or be sure that they're getting effective communication with their client. So in that case, I think it's even more important to have others available, and those names may be given, maybe different in different jurisdictions. Sometimes we talk about personal advocates, which are not legal advocates, but support communication between the person and their lawyer. We can talk about intermediaries, we can talk about communication supporters and others. The other place I would say we can look for inspiration as to what procedural accommodations may be required is to whatever options might be available in the juvenile justice system. Now, again, a word of caution here, because of course I'm very conscious of the infantilization of disabled people, and I'm not suggesting we just adopt wholesale things that exist for children in the criminal justice system and apply them to disabled adults, because that would be inappropriate to say the least. But I do think we should consult with disabled people and their representative organizations, because sometimes there are options or supports available in juvenile justice that could be adapted or reformulated or imagined differently for disabled adults in the criminal justice system. So, for example, systems that provide for the appointment of an independent person during police questioning, where the person might need some additional support. Those can be examples of procedural accommodations, not just in the moment of the criminal trial, but of course in pre-trial as well, which is just as important. So what are the outcomes if we provide procedural accommodations to the defendant? Well, then we can be more certain that we are providing equal protection for their human rights, especially their fair trial rights and their rights to due process. And my final area of concern I want to raise here is diversion from the criminal justice system, particularly into the psychiatric system. So again, the UN Committee on the Rights of Persons with Disabilities has said that we should not be diverting people into involuntary psychiatric detention from the criminal justice system, and also separately that we need to be dismantling and abolishing systems of involuntary psychiatric detention in general. So if there is diversion from the criminal justice system, it should be done on an equal basis with non-disabled people, and it should not be undertaken at the expense of the accused's fair trial or due process rights. And again, we should be careful that it is not amounting to a different form of detention in a different context. So can this be done? Yes, in principle, of course it can be done, but again, we need to return to the concept of free and informed consent of the accused. So in many systems, for example, there's many examples in the US of, sometimes they're called drug treatment courts or veterans courts, where people who have got in trouble with the law, but have some kind of extenuating circumstances. They're living in addiction, they're dealing with trauma from having been in active conflict. And so they are diverted into a parallel system to address those concerns differently there. We have to be really careful if we're taking examples and considering adapting those, because many of those examples, even if there's no explicit coercion, so you're not forced into this, you can choose, you can take your chances in the criminal justice system as it is, or you can opt for this other system if you meet certain criteria. But again, how much of a free choice are we offering people if they don't engage? For example, some of the drug treatment courts require the person to undergo a course of treatment. And if the person refuses to consent to that specific treatment, then they will be incarcerated anyway, or they will be transferred back to the criminal justice system. So in that case, I would say that's more like de facto coercion, and that's not appropriate. We need to move away from that. We need to ensure that any alternatives, whether it's restorative justice options or any other kind of alternative dispute resolution format that's not the criminal justice system, it needs to be based on the free and informed consent of the accused. So what is the outcome of this approach? Well, we will divert based on free and informed consent, but as long as we can be sure that no alternative forms of detention will apply in the parallel system, and that there is no forced psychiatric or other forms of medical treatment on the person as a condition of participating in that system. So that's the challenge that's before us, and there's many more elements to it. I've just touched on a few areas there. And so these are the first steps that we need to take in approaching disability neutrality within our criminal justice system. What I want to close with is a reflection on moving beyond that disability neutrality. And Mia Mingus, who's a disability activist in the US, has talked about transformative justice as a concept beyond even restorative justice, and how that can be imagined in a way that works for disabled people as well as it works for anyone else. So she suggests that we ask ourselves the following questions if we are serious about really transforming how we respond to harm that's created in our communities. And she says, we can ask ourselves, what kind of community infrastructure can we create to support more safety, transparency, sustainability, care, and connection? For example, in a network of community safe houses that those in danger can use, an abundance of community members who are skilled at leading interventions to violence. What are the skills we need to be able to prevent, respond to, heal from, and take accountability for harmful, violent, and abusive behaviours? What do survivors and people who have caused harm need? Why do survivors and people who have caused harm have so few options in our community? And this question, I think, is particularly pertinent for accused people with intellectual and psychosocial disabilities. And finally, what are some of the harmful ways that we treat each other that help set the stage for violence and abuse, and how can we change this? So I think if we're serious about a broader vision for change, we need to embrace this transformative model. But I appreciate that we are also pragmatists in this forum, and we need to adopt some concrete measures in our legal system right now that can help to reduce the harm that's currently caused to accused people with intellectual and psychosocial disabilities in the criminal justice system. So I hope I've given some food for thought there. And again, I'm sure my colleague, Dr. Gooding, will address some of the pragmatic solutions in greater detail, particularly in the context of fitness to plead. But I'm very happy to take any questions. I'm not sure if we're taking, but yes, or to correspond with people after the forum as well.
So please let's hold our questions until after our next speaker. It is my pleasure to invite Dr. Pius Gooding, our next speaker. Dr. Gooding is a research fellow at the University of Melbourne Law School and the Melbourne Social Equity Institute. He is a social legal research concerned with disability and mental health related law, policy, and practice. Dr. Gooding has collaborated with the UN Special Rapporteur for the Rights of People with Disabilities, the UN Special Rapporteur on the Rights to Physical and Mental Health, the UN Economic and Social Commission for Asia and the Pacific, and the World Psychiatric Association. Welcome, Dr. Gooding.
Thank you very much. Thank you, Dr. Kamundia. I'm assuming you can hear me, so I'll proceed and just tell me if you can't. Esteemed guests, ladies and gentlemen, thank you so much for inviting me along to present today. Thank you to the Faculty of Law, to the Kenyan National Commission on Human Rights and Validity, and special greetings to my former colleagues, Dr. Kamundia and Professor Flynn. I'm in a city in lockdown, so if you hear any domestic noises, that's probably my 2-year-old son playing in the apartment. Here in Australia, it's customary for us to acknowledge the country on which we stand, the Aboriginal and Torres Strait Islander countries, and I'd like to pay my respects to the Wurundjeri people of the Kulin Nation and acknowledge their elders past, present and emerging. I'm coming to you from Melbourne, and I thought I'd begin the presentation just with a story about a man named Mr. Marlon Noble, who was the subject of a case before the CRPD committee in 2017, I believe. In 2003, Mr. Noble, who was an Aboriginal man, was found unfit to plead after being charged with a sexual offence in a town called Carnarvon in Western Australia. Now, if he had been convicted of the crime, Mr. Noble would likely have served no more than 3 years in custody, but instead he spent 10 years in prison without any conviction or prospect of a trial. Now, 7 years into that period of imprisonment, the Director of Public Prosecutions abandoned the charges against Mr. Noble after the alleged victims publicly stated that they had no memory of the assault. However, it wasn't until January 2012, 10 years after the charge, that he was released from prison by the Governor, where he'd been held at the Governor's pleasure under the Crimes of Mental Impairment Act of Western Australia. Now, the release was accompanied by a number of conditions on Mr. Noble, who had to be kept under supervision for 24 hours a day. And as I understand, he remains under supervision in the community for 24 hours a day. Now, the case, as I mentioned, was heard before the UN CRPD committee because Australia is part of the, has signed up to the optional protocol for the convention. And the committee determined that Mr. Noble had been subject to inhuman and degrading treatment, and that he had had his right to to equal recognition before the law rather violated, including a failure to provide him with the procedural accommodations during the trial in accordance with Article 13. So I understand that I was invited in part because of my work on unfitness to stand trial laws in Australia and the implications of the Convention on the Rights of Persons with Disabilities. This research was undertaken with my colleagues and was coordinated in particular by Professor Bernadette McSherry and Associate Professor Anna Arstein-Kerslake, who some of you may know. And we worked in partnership with the First Peoples Disability Network, which is the network representing Aboriginal and Torres Strait Islander people with disabilities. We also partnered with 3 community legal centres across the country and trained disability justice support persons, as we name them, who were non-legal advocates who assisted accused persons with cognitive disabilities to assist them to participate in the trial process on an equal basis with others in an effort to assist them to avoid being found unfit to stand trial where possible. These community legal services included 2 Aboriginal-led legal services. In Australia, as Professor Flynn was discussing in relation to the UK, the criteria used in the UK, the criteria for fitness to stand trial are made up of these, which is the ability to understand the charge, plead to the charge, and challenge jurors, and so on. And our provocation or our thesis in the research was that men like Mr. Noble had not been assisted to realise these abilities, and therefore didn't receive the kind of procedural accommodations that would be required under the Crpd. And that as a pragmatic change, that kind of pre-trial support could be an important transitional strategy in moving towards a more rights-based approach to the issues raised by unfitness to stand trial. We trained support persons in partnership with disabled people's organisations, and those support persons were then embedded within the community legal services around Australia, and were assisting persons with cognitive disabilities who are at risk of being found unfit to stand trial, or more broadly, who are at risk of not being able to participate in the justice process on an equal basis with others. The project was accompanied by a broader rights-based analysis of the laws concerning unfitness to stand trial or unfitness to plead, and was released in a report that was published in 2017 and which is available at the Melbourne Social Equity Institute website. So if you are interested, please go to that website and you'll find a large range of resources. And please, again, don't hesitate to be in touch with me if there's anything I can answer particularly. Now, just as some background, Australia is a federal system with 9 jurisdictions, and this is important because the laws concerning unfitness to stand trial, and indeed other special defences like the insanity defence or not guilty by reason of mental impairment, is contained in state and territory-based legislation. Now, what this creates is something of a patchwork where you have different laws that have relatively quite different approaches to what happens to an accused person after they are found unfit to stand trial. So the criteria are stable, but the responses afterwards are different. And I'll explain that in a little more detail, because it's quite handy in looking at where certain laws might be particularly violative of the Convention on the Rights of Persons with Disabilities, and where others might show promise for an alternative path. Australia, just for context, also has about half the population of Kenya. So I'm going to try to answer some of the questions that Dr. Kamundia and her colleagues put to me before I presented. And one was how well are international standards applied by the courts and the executive to ensure the dignity of persons with disabilities in the criminal justice system in Australia. And I would say poorly overall, partly because we don't have a strong legislative system to institute international human rights instruments that Australia has signed up to, but also partly because there hasn't been concerted and national effort to institute more accessible justice systems. However, I have noted that there are exceptions, and these can be quite useful to finding solutions that could be then implemented at the national level, which tends to be how law reform occurs here. One of those is a disability justice strategy that has been adopted in 2 jurisdictions, and that's a strategy to address unequal access to justice. Another important resource that is being used around the country and was just released last year is an equal treatment bench book, which is a resource for judicial officers as well as judges to look at ways that the law can be used to provide accessible measures in courtrooms, in sentencing, and in other processes by the court. Just to dwell for a moment on the disability justice strategies, here's one from the Capital Territory. And the first goal is to assist people with disabilities to understand and express their rights, to participate in decision-making, and to be protected from violence and neglect, and access justice and navigate the justice system with appropriate supports and adjustments. And the second goal is to enhance awareness within the civil and criminal justice system about accessibility. I won't go through, but I can share this presentation and more detail is available for anyone who is interested. I was also asked whether there was still derogatory language used to refer to persons with psychosocial and intellectual disabilities in the criminal procedure codes and legislation. And yes, indeed, there are references to the defence of insanity, but there is a general transition across the country toward the language of impairment and disability, which is replacing outdated and derogatory concepts. But this change in terminology is quite easy, but the underlying ableism is far harder to address. And so to return for a moment to the matter of what happens to persons who are deemed unfit to stand trial by reason of mental impairment, there is variation across jurisdictions when it comes to what happens, and this relates to the extent to which prosecution cases are tested in subsequent special hearings. Now, in some jurisdictions, many defences are available to a person who is having their case against them tested. But in several, and in fact, in the majority of jurisdictions, there are some defences that are simply not available to people who are having the evidence against them tested. And indeed, in 2 jurisdictions, there is no requirement to test the case against the accused persons. And instead, the therapeutic or so-called therapeutic process of the crimes and mental impairment legislation is activated, and the focus turns to placing people in so-called therapeutic environments, which is sometimes simply a prison without any particular therapeutic purpose. And the second major difference is the nature of the custodial orders imposed. So, for example, in Western Australia, where Mr. Noble was incarcerated, he was held at the governor's pleasure. And in Queensland, as I'll speak about shortly, people are held at the pleasure of the Mental Health Tribunal. And that's not in the legislation, but they are essentially held at the discretion of the tribunal, which determines the extent to which someone is detained. And so in effect the person is held indefinitely. So any subsequent detention across Australia of those found unfit occurs in the absence of a conviction. And so from a CRPD perspective, there is an immediate violation. People with disabilities are being punished for things they are not able to, under Australian law, take legal responsibility for. And although the detention might be partly designed to protect the community, the justification for detention without conviction is also partly based on a promise that the person is to be dealt with in a therapeutic environment. But there's about 30 people in Australia in recent years who've been held in jail despite not being convicted of crimes. And so even this notion that they are held in therapeutic environments is not occurring. And so the next question I was asked was whether the procedure makes a distinction between persons with intellectual disabilities and those with psychosocial disabilities. And I would say yes, insofar as there may be alternative procedures. For example, persons who may be in a state of psychosocial distress or crisis, there may be a period of treatment offered before the trial. And there are also alternative custodial and supervision orders, but it can be a real patchwork of what happens. And people with different diagnoses may face wildly different pathways through the justice system. So for example, in my own jurisdiction, if you are someone who is deemed to have an intellectual disability, which is defined in terms of having that disability prior to the age of 18, there are many different programs in prisons and in alternative carceral arrangements within the forensic system. Whereas if you are deemed to have a cognitive disability that developed after the age of 18, all of those options are simply not available to you. So there is a patchwork where the lottery of how you were defined in terms of your disability, if you have a very similar impairment and disability, can mean a major difference to the way you are treated. And so this kind of cruel lottery exists in which a person may receive accommodations or alternative arrangements, but may well not. Another question was whether the country retains the insanity defence, and it certainly does. But the language of mental impairment is used, and certainly no attempts to abolish these defences have occurred recently. But this area is subject to law reform, and unlike in the US or in Sweden, which hasn't had an insanity defence since the 1960s, no such efforts have been made. However, there have been efforts to improve the nature of these, and I would point to the Tasmanian Law Reform Institute's recent report as an attempt to grapple with the implications of the CRPD in this area of law. I was also asked what alternatives exist in law and in practice to deal with persons who are found to have lacked mens rea or to have diminished mental capacity at the time. Now, one innovation in Australia, which I think does warrant attention, is something called the Verdin's principle, which were determined in a case before the Victorian Supreme Court in 2007. And the Court of Appeal stated that mental impairment was relevant to sentencing in at least 5 ways, and they are listed here. Now, they determined that impaired mental functioning may be relevant to sentencing where the condition may reduce the moral culpability, have a bearing on the kind of sentence imposed, be moderated or eliminated general deterrence, and so on. I won't go into detail. Now, no one has undertaken a CRPD-based examination of these principles, and I suspect they would be found wanting, particularly by virtue of referring to impairment and where the outcomes may result in discriminatory sentencing arrangements, including into forced treatment of some variety. But as Professor Flynn noted, the unfitness to, regarding the unfitness to stand trial criteria, it does seem likely that these principles could be reformulated to work in a disability neutral manner, because there does indeed need to be some recognition of the way disability may impact the nature of offending, or rather there must be some recognition that a person's particular way of being and doing may have an impact on the nature of offending and the way it should be regarded before the courts. We have, as I mentioned, something akin to Kenya's presidential pleasure sentencing, whereby the West Australian government has this power. Now, the Australian government was strongly criticised by the CRPD committee regarding Mr. Noble's treatment, but it fell back to a fairly weak response that it didn't have jurisdiction over the criminal laws of Western Australia. And the West Australian government has mostly been pushed into action by a concerted civil society advocacy campaign regarding Mr. Noble's treatment, including alliances with journalists and disabled people's organisations. So my only recommendation would be that sometimes those kinds of public advocacy campaigns have been successful in Australia in overturning the governor's pleasure process. I was asked to consider what reasonable accommodation in prisons looks like for persons with psychosocial and intellectual disabilities. Now, my research focused on the pre-trial process rather than the prison context. And I was contemplating this question and I thought, well, reasonable accommodation into what? Professor Flynn's presentation, I think, gave a really good account of why we should consider, well, is it enough to simply provide reasonable accommodation within a prison system that is not fit for purpose? Now, in my own jurisdiction, nearly half of all prison entrants report being diagnosed with a mental health condition, which equates to about 40,000 people a year. And the rate of brain injury amongst prisoners is extraordinarily high, with one study finding that 42% of male prisoners and 33% of female prisoners were assessed as having an acquired brain injury. So statistics like this lead to the question asked by some of whether prisons are a form of institutions for people with disabilities. Now, I think that's a narrow view, and I think institutions are also appearing in sort of community-based carceral systems. But there is a danger that we are providing accessibility to something that is structurally, simply by virtue of the way it works, discriminatory, because it warehouses undesirable populations, of which a large proportion are disabled persons. So I include this photograph here of an accessibility measure that has simply no purpose. And so I'm not suggesting that there should be no effort to provide reasonable accommodation, but I am suggesting that a narrow focus on that can undercut efforts to transform the criminal justice system in accordance with restorative, redistributive, and indeed, as Professor Flynn set out, transformative principles. And I think DPOs are in a very good position to carry out an audit for reasonable accommodation in these kinds of settings. We've also had some success in Victoria with advocates in prison disciplinary hearings, because those are sites in which people with disabilities in particular can face repeated disciplinary findings, which can lead to their sentences being extended. So I realize I'm coming toward the end of my allocated time. I've already partially answered this. Do mental health courts exist? Yes, they do exist. But no, I would suggest they do not conform with the CRPD, because as I mentioned, in Queensland, indefinite detention is at the mental health tribunal's pleasure. Now, that's not the terminology in the legislation, but it is effectively the case. And if unfitness is the issue in Queensland, then there is simply no attempt to put the Crown to proof and prove the evidence against the accused person. The hearings are closed to the public. Its judgments are not published under the guise of confidentiality, and those who appear before it cannot be identified. Now, if there was ever sort of example of something that doesn't accord with the procedural accommodations and the vision for justice in the CRPD, I think that would be it. Now, it's not to suggest that there aren't good examples where mental health tribunals have provided something that might inform the search for a criminal justice system in accordance with the CRPD, but I would suggest that moving in that direction warrants great caution. So finally, I was asked to make some recommendations, and I just wanted to stick to three. In terms of the research I'm familiar with, I think ensuring that people with disabilities receive support in order that they can understand and participate in criminal justice processes, including procedures in police stations and in courts, is simply a must-have. You cannot avoid having this kind of provision. And again, I am happy to provide research around what can be effective in that regard. And Professor Flynn has spoken about court intermediaries, but I think our Disability Justice Support Persons program also provides an option outside the court in the Defence Counsel side of things. Second, I think disability justice strategies developed in collaboration with DPOs and prisoner advocacy bodies can help ensure system-wide change. This is not a disability issue alone. The criminal justice system in many countries is failing many groups. And finally, just as the CRPD requires inclusive, not segregated education, and I think many people accept that proposition, I think it's important for us to investigate how transformative equality under the CRPD requires new ways of approaching justice and disability. i.e. not just an expansion of forensic disability services. I think it's much harder to prosecute this argument in the criminal justice system, but I think we must pursue it. That brings me to the end of my presentation. I'm very grateful to the organisers. I'm very grateful to you all for taking the time to listen to my presentation, and I sincerely hope that it's helpful in your own efforts. And I'm happy to answer any questions and participate in discussion.
Once again, thank you so much, Dr. Gooding. A really excellent presentation. We have especially really appreciated the practical insights that you have shared with us. I think it's useful now for us to open this session up for question and answers. And since I have the mic, please allow me to begin by asking, other than medical evidence, what other evidence should be considered by courts in situations of unfitness to plead? Professor Eleanor, you mentioned something about going beyond merely medical evidence, and I'm keen to know what else might be useful in these situations. So now, opening it up to our participants first, to our physical participants, and then we'll read out what will be the question that will be posed in the chat.
So should I answer at this stage, Elizabeth, or do you want me to wait?
Sorry, please let's take at least one and then
Sure.
you can provide your insight.
My name is Douglas Otieno from Tinada Youth Organization. I just wanted to check if there is the best practice for community-based in terms of referrals and litigation. And we can pick it in any country, and how can we use it? The best referral pathways for litigation. Thank you.
Thank you for your question. Over to you, Professor Flynn.
Sure, thank you for those questions. I'll start with the first one that you posed, Elizabeth, about what kinds of evidence other than medical evidence. So I was thinking, what are the conditions or situations in which someone might not be able to participate in the trial that maybe don't relate to disability at all? So it might be literacy, which can be interrelated to disability perhaps, or it might be different like cultural understandings of the process, or deference to authority, and therefore not actually understanding that you can defend yourself here. So what kinds of evidence could be introduced? Well, we don't need a medic to tell us somebody's literacy level or their fluency in a language, so we can use other kinds of professional input for that, but also and like including things like social work if that's relevant, or if someone is part of a particular minority community, then perhaps leaders in that community can attest to what membership of that community means, and why the person, if the person has a particular religious belief that makes it difficult for them to do certain things or things like that. We should be more holistic, I guess, in our understanding of what is relevant evidence for fitness to stand trial. And then the question about what are the viable referral pathways away from the criminal justice system. So again, I guess, we can think about the different ways in which alternatives have been established. So there are restorative justice pilot projects in many contexts. There's one I'm familiar with in Ireland where that works particularly with people from disadvantaged socioeconomic areas who come into the criminal justice system at a higher proportion. And so in cases where, again, it's the first offence, it's a relatively minor offence, there can be a transfer, if the judge agrees, out of the criminal justice system, and a process of resolution between the person who's accused and the person who is the victim or has experienced the harm, if they both agree to engage in a process of mutual reconciliation. So that's just one example of a referral away from the criminal justice system that doesn't violate the human rights obligations under the UN Convention on the Rights of Persons with Disabilities.
Thank you very much, Professor Flynn, for that response. Dr. Gooding, would you like to add something else to that, or shall we take the next round of questions from the room?
I can just elaborate to say that I think pointing to issues of literacy is important, because many of the pretrial supports that I was describing could apply to many groups who face challenges in engaging with courts. So, for example, people, not just those who have low literacy, but those who are experiencing considerable physical pain, people who are finding the process extraordinarily stressful, people who have survived traumatic experiences, and so on. And maybe another group that could be mentioned that isn't medical are communication assistants. I think there are many ways of providing communication assistance that doesn't draw on the highly medicalized traditions of some aspects of speech pathology, as it's sometimes described, but there are communication experts, and I can point to several examples in New Zealand or Aotearoa. There are some excellent communication specialists whose contribution to courts has led to alternative practices for a range of people, including those with disabilities, but many others. And in terms of referral, I think I could point to various kind of community-based strategies similar to Professor Flynn. But I think one thing I would say here, and I'm not a criminal lawyer or someone who specializes in criminal law, is that those who do specialize in criminal law and who are aware of these alternative practices need to be part of this conversation. We are going to be very limited if we only incorporate those with expertise on disability into these discussions. Thank you.
Thank you. Thank you for those insights, Dr. Gooding. Masharia?
Thank you very much for both of the presenters. And my question appears to have appeared in both of the presentations, whereby in some jurisdictions, a person may be sent to a rehabilitative facility instead of going through the normal justice system. And you find that that also could be an exposure to coerced or forced treatment that a person is not willing to. And again, you find that the person has been removed from the justice system to another department, either under the Minister of Health or under the Minister of Interior as per our jurisdiction. Now, what could be the best way forward? Should this person still remain in the justice system, and then all the support services be offered within the criminal justice system, or which could be the best way forward?
And please, let's take a question also from Prof. Ambani before we hand over to our speakers.
Yeah, mine is just a challenge that I've been reflecting upon, whereby I want to champion for the right of agency for a person with intellectual and psychosocial disability to be able, for example, to appoint their own advocate. At the same time, I am the one who has been having this opinion that this whole thing of being taken through trial and being found to have had, to be guilty but insane should be taken away. And sometimes I feel like I'm speaking from both sides of my mouth, contradicting myself. Is there a way we can get a middle ground so that we reconcile both the capacity to commit a crime and also the capacity to do certain things like sign a will or hire a lawyer for a person with mental disabilities? Thank you.
So over to you, Eleanor and Pius.
Sure. So yeah, the first question, I think this is a common concern in many jurisdictions. I often hear, but the person only got the support they need when they enter the criminal justice system. And my response to that would be, we have to change that then. That's not acceptable, that the only way to get the proper services or support was to be incarcerated. This is not acceptable. We need to invest in the services and supports that people need in the community so that we don't end up in this like terrible situation where we're trying to keep the person within the criminal justice system so they can have access to basic things that they need. So that's not acceptable, and we need to challenge that wherever. I understand that's the reality, the lived reality on the ground, but we need to address it. And then that relates quite well to the second question about, how can we say on the one hand that people should have the right to make decisions, and then on the other hand say, but let's exempt them from the criminal justice system because we don't like the outcomes. We don't think that it's fair, or that we think that they're disproportionately disadvantaged within that system. And I think we can recognize that the criminal justice system is not a good place for disabled people, but still argue for me, the middle ground is procedural accommodation within that system to make sure that people have an equal opportunity to participate as much as possible, while at the same time continuing to provide the support so that if someone is found not guilty or not to have the ability to stand trial or to be found criminally responsible because they don't have sufficient intent to commit the crime, then we can only offer and continue to offer the supports that would assist people to live and build back their lives in the community. We cannot impose them. If we impose them, we are doing the same kind of harm that we are criticizing the criminal justice system for.
I would only add a response to the first question. I think Professor Flynn has answered the second question as comprehensively as possible. But with regard to the first question, I confronted this very question when I was coordinating the research program here in Australia. And I would say this to defence lawyers: you do what's in the legal interests of your client right now, and take all consideration of what's going to be the best outcome. And if that means pleading a special defence, in this instance, you do it. But to policymakers and to advocates, I say, no, that's not an ideal justice system. We need to do better. And I would say the same to parents who are considering segregated schooling. You have to do the best by your child under current conditions. And if the best education opportunities are in segregated and separate schooling, that might be the best for your child. But it's an unacceptable policy under the CRPD, and it must change. It's not to compare prisoners with disabilities with children, but it's to suggest that you can think about the different contexts of the education system and the justice system together, and think that it might be pragmatically beneficial to a person to be in a forensic facility where they have access to more services. And I saw this countless times in Australia as an argument against transforming the justice system more broadly. People would say, this person has more resources in the forensic system than they would if they were not in the criminal justice system at all, if they were in the community. I just thought that's a very perverse situation where, in order to access the services they need, they have to go through the criminal courts. It doesn't seem acceptable.
So I see two more questions, and I am aware that Professor Flynn and Dr. Gooding need to leave and are quite pressed for time. So the final two. I don't think, Elizabeth, I will be asking a question, but allow me kindly to think like an academic. Related to your question, Prof. Yeah, because I think also in our jurisdiction, the paradigm is changing. And quite correctly, as Professor Flynn has said, is what we are moving. And, I was going through the jurisprudence currently that is in Kenya, and we are shifting to making conclusions that super modible, that persons with mental illness can also make decisions. Yeah, because it's not everyone who has this disability is not going through treatment. And at the point where they are going through treatment, they are able to make their own decisions. And one case law was where a person was charged with rape in Kenya. And what the magistrate did was to say this, because in rape, it is a prerequisite that consent must be established before conviction, as like in defilement cases. So what the magistrate said is this is a person who was incapacitated by virtue of mental illness to make consent. And by that vitiation, the accused person automatically was guilty. So this matter went to the High Court on appeal. And what did the judge say? The judge said, no, that is not true. Merely because this person has a mental disability does not mean that they cannot make capacity to consent. And if you'd allow me, let me just make a quote, what the High Court said, referring to Article 12 of Crpd. In conclusion, it would be amiss if I did not mention that the approach taken by the prosecution and the learned magistrate is that the complainant is an object of social protection rather than a subject capable of having rights, including the right to make the decision whether to have sexual intercourse. This approach is inconsistent with the provisions of Article 12 of the Convention on Rights of Persons with Disabilities, which requires the state parties to recognize persons with disabilities as individuals before the law, possessing legal capacity to act on legal equal basis with others. Kenya ratified this convention in 2008, and by dint of Article 2(6) of the Constitution, as we know, it forms part of laws in Kenya. It is therefore improper and inconsistent with the convention and an affront to the right of dignity of a person protected by Article 28 to label any person as mentally retarded and proceed on the basis that the person is incapable of making a free choice to engage in sexual intercourse. So in conclusion, what I'm saying is this: by virtue of CPRD, persons with mental disabilities ought to be considered as normal persons, save in particular exemptions when a particular issue of commission or omission is at hand. And just to say that a person was suffering from a mental disability does not mean at that particular moment they could not consent to doing something. And therefore, Professor, I would think from an academic point of view, it is a question that we can interrogate. And I think a person with mental disability too can make a will, subject to some particular exemptions. So just a rejoinder, and I'm saying this because I know you have a discussion on local and regional perspectives. I may not be there. I had made a lot of collections of case comparisons, which I can still share with you, notwithstanding that I may not be present, but it's a very interesting discussion. So what Flynn is saying is good, but it is a question that requires a lot of interrogation. So they are normal persons. Thank you.
Thank you, Lady Justice Ngenye, for highlighting the Wilson-Siringi decision, which is indeed very, very progressive. It's one of the ones we are quite proud of, just for highlighting the right to legal capacity. Matthew, 1 minute, and then back to Professor Flynn and Dr. Gooding.
Thank you so much, Elizabeth. My question is in regards to diversion. Does diversion expand you from a criminal record once you enter the system? Yeah, that's my first question. My second question is, in case diversion happens, what remedies would the law provide to the injured party? Yeah, thank you so much.
Thank you, Matthew. Over to you, Eleanor and Pius.
Thank you. Yes, just to address that specific question. So it depends, but often, yes, diversion does involve there will be no criminal record for the person. Now it depends on how it's done, but it's typically that the judge would agree to divert the person, and then a report will have to come back to the judge before they expunge the criminal process entirely. So what will happen is at the conclusion of, let's say, a restorative justice process, where both parties are now satisfied the process has been concluded, the report will go back to the judge, and then the judge will say, okay, I'm closing this matter. But if the process disintegrates during that diversion, the person isn't engaging with the process, or it doesn't reach a successful outcome, then it may come back to court and it may re-enter the criminal justice system at that stage. And the question then as to what remedies are available for victims in that process. So again, a wide range, it depends, but often victims will say that they find a process like this more helpful because they get to set what the goal is. So, you know, in some cases it might be that like this was a case of property damage, and so we can easily repair, you know, the harm caused, but also, you know, we can talk about how this happened and try to make, you know, plans so that similar things don't occur again, and understand how I, as someone who's, you know, done this harm, how have I affected this person and their family and their business and their livelihood and so on. So often people find that more helpful than a criminal conviction in terms of practically for them as a victim. But again, it's up to the victim and the accused in these restorative processes to set what is the goal, what is the outcome of the process, what does someone want, and is it even possible to achieve that? Because sometimes what somebody wants, you know, it's not possible to achieve through this process. So it does not work for every type of harm caused, absolutely, but I think it can be quite a flexible response, and it can develop more imaginative solutions.
I would just add that similarly, the kind of diversion programs I'm aware of would not involve a criminal conviction if the plans were adhered to. However, there have been some criticisms here about the way in which those who are diverted into programs face an additional scrutiny that means that they have the potential to become enmeshed in the criminal justice system, where the oversight of this treatment results in greater scrutiny of their activity, and therefore greater possibility that they will be seen to breach that order or violate the law in some other way. So there's a possibility of over-policing, which undermines the effort of the diversion and results in the person becoming enmeshed, not just in the criminal justice system, but in what some academics refer to as carceral approaches to care. The work of Dr. Linda Steele has been perhaps the most advanced here in Australia. Someone in the chat asked about whether detained at the pleasure of the president or governor should be replaced. And I would just caution against trying to reformulate this approach and instead point to the kind of legal reforms that have resulted in there being set, at the very least, set times that a person's sentence proceeds. And rather than retaining the indefinite detention function, which a 6-monthly review process, whether it's undertaken by an administrative body or whoever, can simply result in indefinite detention by other means, should instead focus on these measures to ensure that a person is convicted with consideration of their disability or acquitted and therefore free to go. And this might require reformulating a determination of unfitness to stand trial and might result in something akin to a facilitated trial where the defences are still available to the person. But this takes us into quite exploratory law reform territory, which I think deserves full scrutiny and a deeper investigation. I think this is the launching pad for new and very exciting research in this area.
The comments in the chat are testament to the richness of the presentations, but I'm quite aware that you need to go. So we are going to release you with our blessings and our deep gratitude as we go into housekeeping and other aspects. So one final clap for our
Thank you so much.
Thank you very much. All right, so at this stage, I know that there are still burning issues and comments in the chat, and we shall continue to have these discussions in the sessions to come, but I think we are in need of a health break. So let's take 10 minutes, I'm advised, so that we can then come back to hear from our next speakers, David Wardell and Charlotte Orrell. Thank you very much.
And get your tea. I will kindly ask, because we have some people who've been waiting to speak from the UK, kindly after you've grabbed your tea and your snack, come.
There, he helps to devise and deliver the legal training course for registered intermediaries. He has written and spoken extensively about intermediaries and vulnerable witnesses, and he's a founding board member of the Advocate Gateway, a contributor to Current Law Week, a bencher of Middle Temple, and an honorary door tenant of Red Lion Chambers. It is my pleasure to give the floor to you, David Watson. You're very welcome.
Can you hear me? I've unmuted myself.
Yes, we can hear you. Please
excellent. Thank you very much. Can I say I'm here really as a team with my colleague, Charlotte, and we're both, who's going to follow on after me, and we're both very honored to be invited to take part in this conference. Our knowledge, of course, really only goes as far as being able to relate what happens in England, but we'd be delighted if any of this is helpful to your discussions here, or indeed something that can enter into your discussions in your individual countries, or whether it's just interesting in itself. And I should say I'm grateful as well for having listened in to what Dr. Goulding and Professor Flynn said, and that actually it makes my, as you'll discover, it makes my life a bit easier in what I'm going to say. Our invitation originates, for our involvement in the intermediary scheme. Charlotte is going to speak, who's a very experienced intermediary, will speak in much more detail about how it works and what she's done. But also because of our involvement in the Advocates Gateway. This was started in 2013, co-founded by our chair, Professor Penny Cooper, as a free online resource to provide practical evidence-based guidance about vulnerable people in the courts. The most important resource on the website is the toolkits, which contain that evidence-based guidance. When we say vulnerable people, that of course includes, it takes in a wider group than the focus of this conference, but the toolkits are designed to be useful to anyone listening. And in fact, there is one which specifically is about how to question people with learning disabilities and intellectual difficulties. And I can only recommend that you go onto the website and hopefully we can be of assistance to anyone when it comes to practice. Because what we've tried to do is to draw together all the elements of good practice in dealing with witnesses and defendants, so that everyone in the criminal courts that is both witnesses and defendants, are treated in the way that they should be. Witnesses, so they can give the best evidence. Defendants, so they can participate in their own trials. We've heard the word participate already in this conference. It's a word which has really only come in the last few years in England. It's an important concept. And I'm happy to note, just to digress for very briefly, that it's now spread into our civil and family courts, whose procedure rules now include a duty to make sure that litigants and witnesses participate in the case. So that's a good news story. I'm going to outline first briefly how we've got to where we are and what's available, but I am, of course, conscious of your guidance questions. I mean, one, if I can just deal very briefly with some of the things that have been said so far. Of course, you've had a discussion already on presidential pleasure sentencing. That, of course, you can blame probably this country for having invented people being incarcerated at Her Majesty's pleasure. What is more often here is that people have been sentenced to what's called an indeterminate sentence, which means that they remain in prison until they cease to be a danger to the public. That's ascertained by the parole board, which hopefully has an independent function in deciding this. Unfortunately, as very often happens in the criminal justice system, when they make a controversial decision, it gets into the press and tends to undermine what, in fact, is their otherwise good work. As far as fitness to plead is concerned, I'm very glad that Professor Flynn went through that, because that saves me the time that I was going to spend on that, in dealing in that. But what I would like to add, with an apology at the end, is the fact that in 2016, the Law Commission in this country published a paper about fitness to plead. The Law Commission was set up many years ago in order to propose reforms in the law, and it's been very wide-ranging in all the aspects. They spent a number of years on this issue, dealing with exactly the problems and the issues that have already been aired about the Pritchard Test. And I took part in some of those consultations, and some of their recommendations, and I think if I can just outline them very briefly, deal with some of the things which I say which have been mentioned already, which includes, for example, a full trial for a vulnerable witness or someone with mental disabilities, wherever that is fair and practical, where someone is lacking capacity, a diversion out of the criminal justice system where that's appropriate, having regard obviously to the facts of the case and the person, a fair procedure to scrutinize the allegation, and effective and robust community disposal, participation issues, and training to identify participant difficulties for judges and advocates. They particularly honed in on the defendant's decision-making capacity and whether they're able to participate effectively in their trial. I don't want to spend any more time on that. It's on their website. It's well worth reading for anyone who is interested in those recommendations and as a way forward. My apology is the fact that the government is obliged to respond to any report like that put forward by the Law Commission. They responded in 2016 when it was published in a letter saying, effectively, thank you very much, you've done a fabulous job and you'll hear from us quite soon. But they never have. And 5 years have gone by and the government has not taken those recommendations forward. So if it's any consolation, this is a story with starts and stops. But one of the recommendations that they did concerned intermediaries, and I will get on to that. The problem, Professor Flynn referred to, of course, the fact that there is a statute which allows intermediaries for defendants. It only allows intermediaries while the defendant is giving evidence. That was brought in 2009, perhaps someone's idea of equality between the defendant giving evidence and prosecution witnesses giving evidence, because they already were entitled to be assisted by an intermediary where appropriate. There is no statutory right to an intermediary for a defendant, either for giving evidence or throughout the trial. That was one of the recommendations of the Law Commission that should happen, but sadly has not happened. And to make matters worse, that statutory provision allowing intermediaries for a defendant when giving evidence, which was passed in 2009, has never been brought into effect. It's only been 12 years. The glimmer of hope is the fact that it was brought into effect in Northern Ireland when they brought in intermediaries, and Professor Cooper and I took part in the first training of them, and this goes back now several years. They brought it in both for witnesses and defendants when giving evidence, because the judges in Northern Ireland put their foot down and said, you're not doing it for one but not the other, it's not fair. I'm sure many judges in England would feel the same way, but unfortunately they don't have the ear of the government. So that's futures intermediaries for defendants. As you said, it's really been entirely up to the judges to decide what to do, and there have been two aspects in law. One was, unfortunately, the attitude as enunciated in a case in I think about 2011, that intermediaries should only be used in a defendant's evidence rarely, and very rarely, when participating in the trial. Now, you may want to ask why in the world should that restriction be put on the use of an intermediary? Surely it's a question of the individual defendant themselves and what their needs are. And that's a very good question, and there isn't really much of an answer. One suspects that the Lord Chief Justice and the Divisional Court who came up with this felt that it was expensive, and that somehow the courts would be able to accommodate a defendant's needs. Another glimmer of hope came in April of this year, when the criminal procedure rules were amended and brought up to date as they are very regularly. And it now includes this particular rule: the court must exercise its power to appoint an intermediary to facilitate a defendant's effective participation in the trial by reason of age or physical or mental disability, and where the appointment is necessary for that purpose, which sounds marvelous, except, of course, the rules then give a very large number of criteria, and they keep intact all the judgments of our Court of Appeal, which unfortunately came down on the side of, is it really necessary? Is it rare when it should be done very rarely throughout a trial? Interestingly, one of the main reason given for this approach for defendants was given by the then Lord Chief Justice in a case called Rashid, in which he said that the reason that intermediaries may not be necessary as often as you think they should be is because the judge can assume that the advocates have undergone training and are able to ask simple and appropriate questions and do everything that they need to do in order to deal appropriately with a vulnerable witness when they're giving evidence, and indeed in dealing with a defendant. That was rather a brave assumption, because he had absolutely no basis for thinking that. Certainly at the time, there has been training for advocates. It began actually after the Rashid decision, interestingly enough. It was an initiative by our Advocacy Training Council, now the Inns of Court College of Advocacy, who devised a very interesting and useful course It took them 4 years to devise it. That's a warning for those of you who leave it to barristers to do these things on their own. It has now been rolled out, and the majority of the great majority of criminal practitioners have now taken the course. How well have they done or not done? It's not assessed. That was at the insistence of the criminal bar. Everybody passes by taking the course, but one hopes that it has made some difference. So training is out there, and the judges, in fact, do have to undergo training before they're allowed to do serious sexual offenses in court. Well, our own commitment to access to justice in this country means that if someone has been the victim of a crime, they're entitled to be heard by the police and heard by the courts, even though they may be children of a very young age. We've had children give evidence as young as 3 or 4, or people with physical or mental disabilities. What really started the ball rolling in this country, though, was the question of children being able to give evidence. And in 1999, Parliament passed an act containing what we now call special measures, which applied, as I say, to all vulnerable witnesses. That's the phrase we take in for everyone. The definition, which includes everyone that the conference is concerned with, is the quality, this is what's in the statute, I'm paraphrasing, is the quality of their evidence likely to be diminished by reason of a mental disorder or a significant impairment of intelligence and social functioning. We don't have a more specific definition than that. Whether somebody falls into that category is a question, obviously, for each individual, based on evidence. And of course, there may be reports or family information or previous involvement with social services, which can ascertain that. No one would suggest that the people that this conference is particularly concerned with would not fall into that category. But they are deemed competent to give evidence if they can give answers, if they can understand questions which are put to them and give answers which are understood. That is in the 1999 statute as well, and was reiterated in the case, rather important here, called B in 2010, where counsel had suggested that if a young girl of 4 couldn't understand his style of cross-examination, she wasn't competent to give evidence. And the Court of Appeals said, no, that's completely the wrong approach to take. What we have recognized as well, that depending on the degree of disability or age, because that obviously comes into the Act importantly, the witness can fulfill the criteria if something is put in place to help them. And having something to put in place has been the breakthrough, because of course the mischief that we're trying to get over was of course very much the idea that if you have a disability, the criminal justice system will simply discount you because you won't be able to stand up to cross-examination. Defendants, of course, were in a rather different situation. The special measures are the use of screens so that the witness in court can't see the defendant, giving evidence by live link. Now, defendant is able to take advantage of that. And it means, of course, that they're sitting in a separate room and the advocates are in the court normally, and they speak to the person through the screen and everyone can see and hear them. Videoing the evidence in chief, that is something, again, which is only available to prosecution witnesses. Normally, of course, the police take a statement from a complainant or witness, but if it's not appropriate to do that, they can record the interview through a question and answer system, and then that then is played as the evidence in chief. Videoing the cross-examination before the trial as well. That was one of our particular innovations. And the idea really was designed that they could finish their evidence before the trial takes place. The idea being that it'd be done much sooner, the trial being dragged on for some time after that. There's quite a bit of discussion as to the appropriateness of that as opposed to trying to accelerate the trial itself. But just to give you an idea of how long things can take, this idea of pre-recorded cross-examination was first put forward in a report in 1989. The pilots to do it began in 2014, and it's been rolled out nationally in 2020. So again, as I say, these things don't always happen quickly. Using devices and the use of intermediaries, and Charlotte will deal with that. But once again, none of this included defendants. The government back in 1999, when the act was passed, said that they're on the side of victims and witnesses. And every government since then, including the present one, has said exactly the same thing. We're here for victims and witnesses. And I'm afraid cynically, there are no votes in a fair trial. The idea being that somehow the defendants can be looked after by their solicitors. Well, of course, to some extent, yes, when it comes to lots of the legal things, but not when it comes to assisting them to take part meaningfully in their own trial. But there one needs intermediaries where appropriate and adjustments. And that again is something that intermediaries really have brought to the courts. But also, Charlotte will explain this more fully, things like slowing the procedure down, making sure they understand, and using language. And when we were training intermediaries at one stage now some years ago, we took them to the Old Bailey to observe what a real trial looks like. And of course, one of the dramatic moments came when they heard a bit of evidence, and then the lawyers discussed a point of law with the judge, and the vocabulary changed totally, because lawyers are used to talking in an highly educated, jargon-laden way, which is fine when you're talking to the judge, but not much good if you're dealing with a defendant or a witness. So this is where we hope the Advocates Gateway is going to be useful, because once it's been established that someone has the difficulty, what can be done to make sure that they're looked after in the courts? And some of it is about what happens beforehand, things like whether it's court visits, whether it's practicing on the live link. And it's especially important, obviously, for the advocates, and that's the particular guidance that we give in the toolkits as to how to question people with disabilities, which may include the defendant, because they may well never have done it before. I'm afraid this is only, I'm looking at the time, only an outline. In England as well, we have the criminal practice directions, which, as I said, have been developed over time to reflect what is developing good practice. The judges have an equal treatment bench book, which gives them guidance. All this obviously has been developed in the context of the English system. All I would say about it is the best thing that everyone can aim at, having regard to their system and the context in which they're working, is to try to develop a body of what is good practice. And that's the signpost that everybody can aim for, because the principle that everyone should have access to justice is, of course, universal. So I think over to Charlotte, and I think we'll both be happy to take questions in due course. Thank you.
So thank you very much, David. I really appreciated your presentation, which has highlighted the differential treatment that is often given to witnesses and victims as opposed to accused persons. I think we agree that in the Kenyan context, it's the same way. So thank you for those very practical insights. And please now allow me to introduce Charlotte Ora. Charlotte has worked as a speech and language therapist since 2003. Over this time, she has developed specialist experience working with children and young people with complex communication needs, including autism, learning disability, and challenging behavior. Charlotte has also worked as a registered intermediary since 2008, facilitating communication with children and young people with communication needs whose evidence is required at police interview and at trial. Welcome, Charlotte.
Hello. Can you hear me okay?
Yes, we can.
Okay, great. I'm just going to share my presentation. I'm hoping that you'll be able to see that too. Okay. Is that something you can see now in my presentation on the screen? Apologies, I can't see what you can see. Yeah.
Yes, we
great.
can.
Great.
Thank you.
Great, lovely. I could just echo David's comments that he made, and it's really brilliant to be able to be with you today. I'm really sorry that we can't actually be with you in person. And yeah, we really welcome the opportunity to talk about some of the work that we've been doing here in England, and hopefully that will be of interest to you there. So what I'm hoping to do really today is to bring alive some of the things that have been discussed already. David's talked about how the registered intermediary scheme is set up in England, and what I'm hoping to do is actually talk about two cases that I've actually been involved with, just to bring it to life and to show the practical strategies and recommendations that we as intermediaries are able to bring. I'm going to talk about a case that I've been involved with where I've supported communication between a witness and the police at that early investigative stage, and then I'm going to talk about a case that I've been involved with that went to court and the things that I was involved with there. These are real cases. I have changed the names of the people involved. Both involve witnesses rather than defendants. And again, as David talked about, that's a feature of the majority of intermediary work has historically been with witnesses. However, there is a shift, and the sorts of things that I would be doing and discussing, doing assessment techniques, etc., would be also done with someone who is a defendant. Yeah, hopefully that will have interest. So I'm first going to talk a little bit about the sorts of assessments that we as intermediaries do. So in effect, all intermediaries, when they meet a witness or a defendant, their job is to complete a communication assessment with a witness or a defendant, and then provide suggestions and strategies accordingly. Again, as been touched on before, everybody is different. Everyone has a different profile of communication strengths and needs. But to help sort of structure our assessment, this is broadly the things that I will be thinking about when I meet any witness. I will be thinking about their attention, their behaviour, their emotional state. How easy is it for them to keep calm? I will be thinking about their ability to understand language. For example, how well they can understand different sentence structures, what we talk about their auditory working memory, for example, how much someone can hold in their head, how much spoken information someone can hold in their head while they analyse it for meaning. I'll be looking as well at their use, how well they can explain an event, a recent experience that they've had. And at assessment stage, I'll be talking about something that's completely unrelated to the actual event that has brought them into the criminal justice system. And I'll be looking at their ability to understand and respond to different types of questions. What we know in this world of intermediaries and vulnerable witnesses is there are different types of questions, and I'll talk about this a bit more. And we know that there are certain types of questions that are much more at risk of producing incomplete, inaccurate responses from witnesses and defendants. So I'll be thinking about that particular person's ability to understand and respond to them. And I'll also be thinking about their speech, how clear they are, and if there's anything that needs to be done there. So I will be looking at their difficulties in all these domains, but really what I'm trying to do is look at what helps in all of these domains, and actually if we can do to tap into somebody's strengths. What we know is that, for example, autistic people, autistic witnesses often have very, very strong visual skills, whereas they may have not so strong abilities with understanding and processing spoken language. So what can I be doing as an intermediary that can tap into their strengths to help them to participate, to help them to explain what's happened to them? So first I'm going to talk about a lady that I helped several years ago. I'm going to call her Jenny. She was 26 when I met her. She had a significant learning disability. I found out some information about her before I met her. I found out that she'd attended a special needs school, and the police officer who was involved in this case talked about her as their language was, oh, she's like a child, she's like a very young child. What the police wanted to explore with her was the allegation of rape by a family friend. Now, this had been reported to the police by the lady's mum, who had actually come into the room and found Jenny and this family friend on the floor in a sexual position, and immediately given Jenny's significant learning disability, called the police about this. The initial assessment that I did with Jenny involved me going to her house, but assessments can happen in different places, but it was felt like this was the best place for her. And the police officer had to be there. Now, this is a crucial part of the intermediary scheme. At no point can I be alone with any witness, just in case there's the allegation that I may have coached them, I may have told her what to say. It makes my involvement in the criminal justice system very transparent. Now, what I knew is that in this case, it was really important for me to assess Jenny's ability to explain and potentially explain positions of people, because this is what had been alleged by her mother. So what I found when I did various different assessment activities, I found that her language was very similar to a child aged chronologically of about 5. And of course, that's different because she is a 26-year-old lady, but in terms of her ability to understand language. And I've also found at assessment that her ability to communicate a recent narrative was very impaired. She could use very short sentences to express what she had experienced. However, what I did find is that she was able to use, I'm just going to show you now, I'm holding up these, so this is what we talk about when we think about strategies to support someone's ability to explain what happened. She was able to use these wooden mannequins to talk about a recent event, and she was able to use these in a way which added to her account. She could give spoken information, but she was able to position these to explain a neutral event, again, nothing related to the actual event that the police wanted to talk to her about. So this was my, well, in brief, this was my recommendations that I gave to the police. This is after the assessment. I discussed it with my findings with the police. We made a plan of how she was going to be interviewed. This is what I suggested, that she did need breaks after 40 minutes just to have a cigarette. Language needed to be very short and specific with no police jargon. And I recommended the use of these mannequins to help her explain position. And I also recommended that questions about times and dates and estimation of number risk leading to inaccurate answers. And I made some suggestions about how these questions could be recommended, how these questions could be reworded. Rather than asking how many times did this happen, we could often say, did this happen once or more than once? And that is quite an effective strategy to reword questions in a way and then explore that in greater detail. So then I can tell you about what happened next. So on a different day, Jenny came to interview suite and was interviewed by a police officer, and I was there. What my job is in that situation is to check and to listen really carefully to the questions that are asked by the police and to intervene if I felt that there was a question that maybe contained police jargon, that was too long, that was slightly ambiguous, and make suggestions accordingly. And what that led to Jenny being able to explain in quite depth what had happened with this family friend, and she was able to use the mannequins again to provide additional information, much more than she was able to do with spoken language alone, that actually supported the information that was given by her mother. So that was an example of a brief example of what the sort of work that intermediaries do with the police. Now, let's think about what happens when this goes to court. So again, I'm going to think about now a different witness now. I'm going to call him Liam. Liam was a 15-year-old boy, a significant mental health concerns, and he was at a high risk of self-harm. I'll talk about that a bit more in detail. And he was living in specialist accommodation for children with behavioural difficulties. He was due to give evidence at court in the trial of his mother. Now, this is quite a different case because it was typically, that's an unusual case for the ones that I've been involved with. It was actually the mother who had been accused of abusing him, sexually abusing him and his younger brother. When I met him, it was very clear he did not want to give evidence. He'd already, as a younger child, he'd completed 2 police interviews where he had talked about what had happened. He was now a bit older. He realised the extent of what had happened and the wrongness, I guess, of what had happened. And he did not want to go to court. In particular, he did not want to be seen by his mother. And he made this very clear that when I met him, his reluctance to do this. The assessment, which is slightly unusual, took place over three different sessions. First time I met him in a police station, and when it was really clear that he didn't want to do it, we then wanted to explore with him what his options might be for giving evidence that might make him feel safer and as happy as he could be in giving evidence. So I arranged two pre-trial visits for him so he could see what his choices would be, where he would be, where his mum would be, and how that might feel. Just to give you another sort of practical example of some of the things that intermediaries do, before I met him, I sent him a letter with a picture of me. And that helps in some ways, well, in many ways, often to build rapport with witnesses. And it gives me a starting point with them. So I'd explain what I do, and when I'm gonna meet him, and really the key thing is here that I need his help. I need him to help me. It's not really the other way around. I'm gonna help you. Often doesn't work. If we put the child in the position as the expert, you're saying, I need your help. To find out what might help you in this situation. And again, as a strategy, it's a simple strategy, but very effective when you start to engage with people. So in terms of what I found when I first met him, and going back to this sort of framework for assessment that we discussed, the difficulty for Liam in particular was in this area of attention, behaviour and emotional state. He was very challenging for me to engage with when I first met him. Building rapport with him was very tricky. He took a long time to build up trust, and I can understand that. But what I did notice was what a good rapport he had with the staff that supported him. And he seemed to trust them a lot. And my strategy in a lot of ways was to go through them. He had difficulty paying attention, looking at me, and he was always fiddling. So again, as a strategy, sometimes we might explore, well, what might help? And again, I'm showing you sometimes having something in your hands like chains, or often people have their own methods of sort of self-regulating and keep calm. That he didn't like that, he didn't want that, and we discussed that. Staff reported how, and Liam reported what a risk he was to himself in terms of self-harm, and if he became very agitated, he would often need to be restrained for his own safety. And he was reported to search through, if he was becoming agitated, he would search through the building looking for sharp objects, looking to hurt himself when distressed. What I found that there were other issues in terms of his language understanding, but yeah, I think that very much related to his emotional state, that he just couldn't keep calm enough to focus on what was happening. And again, his auditory working memory, his ability to hold information in his head and analyze it, was impaired. But again, I think that was more likely to be due to trauma. And he also did not indicate when he had not understood, which is something that we really hope that witnesses do naturally, but often some of them do need reminding or support to do that, or even more importantly, the onus being on the adults to be the ones who are talking clearly. He had good expressive language. So after my assessment, I gave some very clear recommendations. And I've just put a picture there for you, for those of you that might not have seen what a live link looks like. Now, we're also used to using Zoom and FaceTimes now, that to explain it to someone now is so much easier than it was a few years ago. So this is how a live link room might look in England, with the camera and the TV, and just giving evidence into the courtroom via that way. What Liam didn't want was to be seen by his mum, and typically if a witness, or often if the witness gives evidence like this, the mum or the defendant can actually see them, and their alternative is to be in court with a screen, and that's seen as the other choice. Now, actually, it doesn't need to be as binary as that. But in this particular court that Liam was in, they'd never done it like this before. What I wanted was mum not to be able to see this TV that was in the courtroom, and that had never been done in court. And sometimes it's as simple as getting some cardboard and making a screen in the courtroom to stop the view of the TV. And I also suggested that a neutral witness supporter be present, to one of his staff supporters, because there was no way that if he did become agitated, I would be able to physically restrain him to keep him safe. I'm not trained, it's not my role, and it wouldn't be safe for either of us if that was the case. So I suggested that. And I also suggested that we needed to really look through the live link room beforehand to remove all sharp objects. And I suggested that emotive questions were put at the end of the cross-examination. If they were put at the beginning, it would upend him and that would be it. So the things that were seen to be more challenging were sequenced, and this idea of no tag questions. So we know that putting things in this sort of format, this happened, didn't it? We know that these are more challenging for people with communication difficulties. And he needed questions to be asked one at a time. Now, these recommendations had to be discussed at court with a judge, with something called a ground rules hearing. And the judge was very receptive to my suggestions, especially if you can suggest practical ways to deal with what they may say as barriers to doing what I'm suggesting. And the judge came and met Liam beforehand, along with the barristers. And so, yeah, so all of those things were agreed to. And then I was there present with Liam while he was cross-examined by the defence barristers. So yeah, this is my final slide on this, just to give the discussion, to give you the outcome. As I said, everything was agreed to. I was actually given, and this is becoming increasingly common now, for barristers to give the questions to the intermediary in advance, and I can check them rather than stopping them in the middle of the questioning and which interrupts the flow. Often we can check the questions in advance and check and reword them before, and which again is usually a much sort of more efficient way of dealing with it. But that doesn't preclude me being involved, because I still needed to be there. I needed to be sure that it wasn't going too fast for him. He also struggled a lot with his breath control, and that is something that a lot of witnesses do, sort of lose the power to breathe almost. And I was able to sort of help prompt him to breathe. And at the end of it, he did successfully give evidence. And at the end of it, he did give a really fantastic smile of relief that it had all been done, and he was pleased to have done it. And the mother was convicted of all charges. Now, what I think is particularly good for Liam in this situation is that now in this court, once it happens once in a court, in my experience is that then it sets a precedent for it happening again. So some of the things that we suggested there, especially in terms of screening the mum's view of the live link, once that's happened once, then it will get known that that has happened. So not only has Liam managed to help give evidence here for the court, he's actually affected how other children give evidence in the future. And I think that's a real positive, and a positive that I was able to share with him in terms of how well he'd done. Okay, so I think that brings an end to my discussion or my presentation about some of the work that I do as an intermediary with witnesses. Again, really happy to answer questions about that you may have about the work. I'm just going to see how I can disconnect from this. So let me see.
Cases have really brought the situation to life. I mean, haven't they? Haven't the real cases really made it concrete for us? So thank you for the presentation. Thank you for showing us the practical tools and really bringing this issue of accommodations home. And I think that for those who've looked ahead of the program, this really sets the stage for the conversation that takes place tomorrow, led by Fael Odeni of the Kenya Association for the Intellectually Handicapped. But having said that, let's open this up for question and answer. Is there anyone in the room who has a question, or shall I do my usual going ahead? We have questions in the room. So we'll go with Lois, then Petronella, then Matthew, and then we'll come to you, Madam.
Thank you for that really insightful presentation. So my question to Charlotte is, are registered intermediaries trained in psychology or counseling? So is that a background that one has to undertake? The second question is whether registered intermediaries also assist in communication for accused persons and defendants, or is it just limited to witnesses? And whether registered intermediaries, being a registered intermediary is actually an official appointment. That's, yeah, whether it's an official appointment and whether it's something that's present across all courtrooms.
Okay, thank you. Thank you for your questions. So in terms of backgrounds, typically, well, historically, most intermediaries have been speech and language therapists by training. However, that is changing now. I think the crucial thing is that they have a background in working to facilitate communication with the groups of people that they may be assisting in courts. So I'm a speech therapist who with experience of autism and learning disability. Therefore, I feel and I can demonstrate that I can do that work with someone with those needs in court. However, increasingly now we have psychologists who do the work. There's a big gap in registered intermediaries who have a mental health specialism. So I wouldn't take a case, for example, with someone who was schizophrenic. I wouldn't know how. So so you're meant to, as an intermediary, you're meant to put yourself forward for cases that you have a background in. So yeah, so mainly speech therapists. We do have some nurses, some special educational needs teachers. The range of qualifications is broadening, and but I think it isn't enough just to be a speech therapist. We're trained in a certain bit, but not enough. Were you going to comment something on that, David? Or
no, not at all. I think because of the matching, there's a matching service.
Oh yes, that's probably, yes, that's absolutely. So yeah, so what happens is if the police or the courts want an intermediary, there's basically a database, and I'm on a database, and so they put a request into a matching service who then sort of feed out those referrals to people who have proven themselves to be qualified in that area and who geographically live in that area. I hope that answers that question. The one about defendants, yeah, I mean, intermediaries do work with defendants increasingly, not just in giving evidence, which would take a bit of the form that I've just discussed, but would be about this sort of ongoing support during their proceedings. So that might involve them sitting, whispering sometimes to the defendant, what in simplifying in real time what is happening in the court, maybe keeping written notes, maybe keeping a visual, kind of a simplified visual timeline, or different ways, whatever they feel is the most effective way to support their ongoing understanding and of what's happening, which is yeah, absolutely, and becoming more and more the norm, actually. And in terms of the question about official appointments, I'm court appointed. So I guess, but if in that sense, is that what you mean? I'm not sorry if I've not understood that completely, but I'm appointed by the court. So yes, it is an official appointment.
It's the so I think to come in here. When I first started, we first started training them, the idea was that, of course, an intermediate, it was just something that somebody might do in addition to their ordinary job as a speech and language therapist or whatever. One of the problems that arose fairly soon was the issue that the courts don't necessarily work as efficiently as possible. So if you booked in 1 or 2 days because you thought this person was going to be giving evidence then, and then the trial drags on, and in fact you suddenly find you're needed on Thursday rather than Monday, and you have other appointments, and that caused problems. So some intermediaries have done it full time, but they are the important. Yes, something I think we should mention is the question of neutrality. It's very, very essential to the intermediary scheme that everyone needs to realize in court that the intermediaries are neutral, and they're there to help both sides in communicating with either the defendant or the or witness. They're not part of the defense team, and they're not part of the prosecution team. And sometimes people in court find that difficult. But it is a very important thing, and it's something that they've all taken on board and do, and it is just so important to make the scheme work properly.
Thank you. Thank you for those clarifications. I think over to you, Petronella, then Matthew, and then I'll. So let's take 3 questions just to give time for joint responses.
Thank you so much to the 2 very insightful presentations. Actually, my question has been largely answered from Lois's, because what I needed to understand was actually even in terms of regulation of the conduct of intermediaries. And I'm drawing the comparison with what we have in Kenya in terms of the Mediation Accreditation Committee, which is actually, entrenched. We have the act that provides for that, the Civil Procedure Act, and we also have the regulations governing the, the conduct of mediators. That there shall be a Mediation Accreditation Committee, and that they are to conduct, keep a role of mediators, and that they are to develop a code of conduct. So, that was my interest, but likely that has been answered. But also to follow up on, in terms of reports, we had cases
whereby your reports have actually been challenged in terms of the weight to give it, even in terms of court. Have we had the prosecution, for instance, or the other side saying that, we don't agree, and how do you navigate that? Yeah, thank you. Yes, over to you, Matthew.
Thank you so much. And indeed, that was very insightful and a good process to mediate or accommodate. But my question is also one of the questions I had, but has also been touched on by Lois and Petrolina in regards to the requirements or appointments for one to be an intermediary. And she has also talked about the mediation process that we have in Kenya. So I won't touch on that one. But again, I would like to ask in regards, in the CRPD, we have an idea of a sponsor who comes in and in one or another plays such a role as an intermediary. How do these two work together? How is there a conflict? Can there be a conflict, or can there be an aspect of collaboration between the sponsor's role and the intermediary's role in this regard? Thank you so much.
So allow me now to ask my question, which is in relation to our Sexual Offences Act. So under Kenya's Sexual Offences Act, Section 2, an intermediary means a person who is authorized by a court on account of his or her expertise or experience to give evidence on behalf of a vulnerable witness, and may include a parent, a relative, a psychologist, a counselor, a guardian, children's officer, or social worker. I know it's a mouthful, I've pasted it on the chart. But so my question is an intermediary giving evidence on behalf of a witness, or is an intermediary a tool, so to speak, or a means of communication? And also, if you could comment on the fact that our law allows a parent and a relative to act as an intermediary. Over to you, Carlos and David.
Charlotte, I think you better.
Yes, there's lots of questions there. I think I can probably answer. I'll try my best, and then I might give over to David. In terms of the last question, in terms of giving evidence on behalf of or acting as a tool, it's quite an easy answer. I very much see myself as a tool to facilitate the communication of others rather than giving evidence. I think there is always a risk if you have a parent or well, they weren't there potentially, and what you want to know is what happened. And so I think that that is how the intermediary scheme here is very much viewed, as you are facilitating the communication of others rather than speaking for them. It's not my job to speak for somebody else. It's my job to help them to speak for themselves. There was a question about if the courts don't agree with the recommendations, I think, and that can happen. But I think it does happen, but typically the judges are very receptive, and it is just thrashed out at the ground rules hearing. It's just, and some of the recommendations I have made, the judge might decide not to go with. That does happen, but you have to accept it. But there's only been one case in 12 years that I've been involved with where the judge said, "Oh, we don't need you actually," and I think that was in a case of youth court where they felt that they're so used to talking to young people that they felt they had the skills. Whether or not they did, I don't think that they would do. It's in just experience, just that people's way of talking is so ingrained, and use of tag questions, for example, everyone does them. It's very hard to stop. So that's typically how it would happen. and I'm sure David could add to that. I'm sorry that the other question from the gentleman in the room, I didn't catch. I understood it was something about conflict between two roles, but I wasn't sure I heard what the second. It was with between an intermediary, but I'm not sure I heard what the name of the other role was. Apologies.
I think it was sponsor. I'm not sure if it's sponsor or supported decision. Is it within the context of supported decision making or just sponsor? So the role within the convention of supporter or and the role of intermediary.
Yeah, I mean, again, I'll have a go and then I'm sure David can add to it. I mean, often you do have witness supporters here, but they're not allowed to intervene. They're not allowed to talk to the court. And that's where they're almost there for sort of moral support, and they've almost got to sit behind the witness and not get involved, but they're there just to be present. Whereas I can play a much more active role and can be very raising things with the court, etc. Where and I think that I don't think there's a conflict. I think if we do our job well, we can discuss with the supporter, this is what I'm going to be doing, this is what you can do, and together as a team we'll do well, not as a team, because as the point that David made about being neutral, but we can be really clear what we're both doing. So I don't think that there would be a conflict there in my experience.
I think that's right about the certainly about the conflict point. The idea of having a supporter in the room is something fairly recent when we've become much more sensitive to the whole issue of the strain of people giving evidence, and now there's provisions for that. I think there may have been more contested applications for intermediaries in the past, because there was a certain, and you know, when you mention this, because you may experience it if you think of it in your own countries. Because, I mean, exactly, because the advocate said, well, we know how to do this, and we know how to talk to people. And the judges say that as well. And there was a very recent case, actually, in the youth court, where the magistrate who was presiding said that an intermediary was not necessary for this particular person because the issues were very simple. And they didn't, you know, there was not very little that, you know, when it came to understanding and when it came to points of law, it doesn't matter because they're not involved in that anyway. And the appeal court, very interestingly, said, well, no, he's the defendant and he's entitled to understand everything that's going on while it's going on. And that, you know, is you know, very, very useful attitude. So, I mean, there are contested things, and indeed there have been cases fairly recently where a judge says, no, I don't think it's necessary, and they haven't allowed an intermediary, and it's come to the Court of Appeal as to whether the defendant was able to participate meaningfully because of that. So we are at least alive. One of the things that I mean, we always taught them in the training was the fact that the evidence, of course, has to come from the witness. And one of the rules that we sort of really invented, because all the schemes, it's all been invented by, well, you know, asking ourselves what's good practice. This has been going on since 2003 now. And one of the things we thought, well, you must be able to see the intermediary on the screen if they're in the live link room or if they're in the courtroom. So you can see that they're not sort of nodding or doing anything to encourage them or making it clear that what's the right answer, And so they have to sit there, I think, Charlotte, they're rather po-faced during the evidence, which some of them find, and I think we should mention it as well, not necessarily easy because of, frankly, the strain, because of course, some of these cases, you know, are the facts are very, very distressing. And you're sitting there looking very neutral for the whole day. And they developed, I think, a wonderful support system between themselves to unload afterwards because of the stress of what's happened. But they've also managed as well with defendants to help to make them understand what the nature of the offenses are. And that's been one of the other contributions. As I said before, what they've been able to do when they're there for the whole trial is they take part in an initial ground rules hearing before the trial starts, to set down the rules of, when are we going to have breaks and when are we going to explain things, and let's look at the language that's being used and all the things that may not be thought of. And then there's another ground rules hearing before the person gives evidence. And by now, of course, they understand what the person can understand and not. And I'm sure Charlotte's had the experiences they all have, that of course, and any advocate knows this, that of course, once you start a trial, things are unpredictable. And you're rather surprised, you may be surprised to discover that a witness or a defendant can understand some things you didn't think they did and can't understand things you don't think they did. And the court, one of the things we need to persuade the court, and hopefully when started this, is that you've got to be flexible and to understand that it's all going to come out in the wash when the trial starts, and you've got to keep on adjusting and thinking about it as it goes on.
Thank you very much. I think one last question.
Intermediary plays a very important role, and at some point they face a lot of challenges and limitations. I wanted just to understand the challenges and limitations faced by intermediaries and how they can be addressed.
Over to you, Charlotte. Challenges and limitations faced by intermediaries, and what are some of your recommendations on how to address this?
Oh, that's an interesting question. I think it's changed over the time of the intermediary scheme being around. I think to begin with, I think courts were very welcoming, and now I think courts have had more experience of working with different intermediaries. They may have different styles, for example, and so there is a risk for the intermediary scheme. We're all self-employed practitioners. There's very little opportunity, and I think because funding and changes, there's very little opportunity for intermediaries to get together to discuss how they go about their work. So there's an issue with consistency of approach, which we do our best to try, but we're all self-employed, and that creates issues for in itself. And often people are trying to work it out on their own, but we do have local intermediary support groups now. So that I live in an area of the UK called Sussex, and we have an intermediary support group which we get together every few months and we can share practice, which is a good solution. But I think probably where I was going with my first point was that now almost the courts have got a bit used to intermediaries, and they're a bit like, well, we know what you're going to say. You're going to say use simple language. You're going to say that. What's the point of an assessment? And because it's all the same. And actually, and I think that is a big problem now that we're more into the scheme, is to show the value of intermediary work that's more than just simplifying language. And I think that's what I was trying to do with one of my case studies, is show it's not just about talking simply. You've got to look quite holistically at behavior support, and I don't think I've ever written a report that's the same as another report. And I think so it's kind of getting over maybe the criminal court practitioners' views that they've developed of intermediaries, some who are big supporters and some of whom are a bit like, oh, you're stopping us doing our job, we need to ask this sort of question. And do you think that's fair, David, in terms
yes. Yes, I mean, you mentioned certainly at the end, I mean, the system of vetting questions ahead of time, sometimes there is resistance, and there have been cases, we can read, where they've gone to the Court of Appeal and said, I was stopped from putting my case, I was stopped from fully defending. And the Court of Appeal always asks, is there any issue that the jury wasn't aware of in this case? And the answer is always no. And so it's thought that it's been a fair trial. One of the consistency problems, of course, also is within the system itself, because each court develops its own practice of doing things, and all the judges are very keen on things being done well and fair trials. But one also hears of intermediaries sort of going along to one court that they haven't been to and suggesting they do things, and because that's what they're used to at the court they usually go to, and everybody throwing up their hands because they've never heard of it before, and saying, no, we don't do it that way. But that's a problem that we, others have to deal with.
So, I mean, I think it's so person-centered, isn't it? It isn't just a checklist of things to do, but it really seems to depend on the defendant or the witness in terms of. So I think this has been so useful, Charlotte and David, especially in the context of the legal reform that we are undergoing. I think we've seen now that one of the provisions that we need to flag out for amendment is our Section 2 of the Sexual Offences Act, just really making sure that whenever we mention intermediary within our sexual offences law, and indeed any other law, we are talking about a tool of communication rather than someone who's speaking on behalf of someone else. Thank you so much for those clarifications. And I think at this stage, we will need to break for lunch. And for you participants who are joining us virtually to, have a break, walk around and so thank you very, very much, Charlotte.
Thank you. It's a great honor to be asked, and we've been delighted to meet everyone, even virtually.
Yeah, agreed. Enjoy your lunch.
Yes, quite, you've earned it.
Well, we would invite you to enjoy some of our Kenyan delicacies, but maybe the next time.
Oh, yes. I hope so.
Yes, that'd be nice.
Thank you.
Okay, so back in 45 minutes. Shall we aim for that, members? Yeah. So let's aim to be back in 45 minutes. Luciana, over to you.
All right. Thank you so much, Liz. Wow. Can we give Liz a round of applause for leading us so well? Thank you. Wow. It was so nice to be professionally led by Dr. Kamundia, who happens to also be the focal lead on disability at the Commission. So she's very well placed to lead the discussion. As we said, we apologize that we're running a bit later than we would have liked, but we would beg your indulgence because we also would like to get through the afternoon session as well. So we are asking, can we take 45 minutes for lunch instead of the allocated 1 hour? Would that be okay? Okay, that would then mean that we are back here at 2:40, if I'm not mistaken, or thereabouts. Kindly, at 2:30-ish, kindly start shepherding yourself back up. If you see us, then we are really coming to browbeat you to come back in. We hope not to do that. So we are going to be back at 2:40. Thank you, everybody. See you then.